All right. Welcome, everybody. My name is Dana Sparks, and I am the director of the Georgia Real Estate Academy, which is the entity that is offering this class for CE credit. And I am also the managing broker of Maximum One Greater Atlanta and the qualifying broker of Maximum One Greater Atlanta Realtors. The only reason I tell you what my day job is because this is a contracts class. And so I wanted to just give you guys a little bit of context and a little bit of background that I do see contracts that come through our brokerage. Now, I'm not the compliance broker. We've got two compliance brokers, and they see every single contract. I only see the contracts that have issues or questions. So, I see maybe one or two a year, right? No, I just wanted to let you know that I see contracts, not only the GAR contracts, but the RE Forms contracts, as well as HUD contracts, new construction contracts, attorney written contracts. There's a huge variety of contracts out there. So I just wanted to give you a little bit of context and a little bit of background, and wanted to just share that with you. Now, this is let me see if I can. This is a 3-hour CE class. Hang on one second. I need to find the notice to students. All right, give me 1 second. All right. I don't have it there. Shoot. All right, I'm going to read you this one, and we are going to substitute this. 71615. All right, so this is a virtual broadcast for a 3-hour CE class, and this class has been approved by GREC. The school is the Georgia Real Estate Academy, which is GREC school number 6915. The course name is not FHA. The course name is the 2020 RE Forms Contract Dissection, GREC course number 71615. And it is a virtual remote broadcast of an approved in-class course for 3 hours of CE. I'm the instructor. My name is Dana Sparks. There is no required homework or written exam. You must be on the broadcast for the entire time of course material. You guys, you can only get CE credit for one specific course number every 12 months. Now, that doesn't mean topic. That means course number through a particular school. I'll go over that in just one more second. And no recruiting. There's no recruiting for employment opportunities for any real estate brokerage firm during the class or on school premises. For a Zoom class, I'm not quite sure what school premises is. If there is, please report it promptly to either GREC or myself. I am the director of this school, the Georgia Real Estate Academy, or Heidi Kelly is the coordinator, and there is our contact information right there. So basically what that means is you could take a contracts class for all 36 hours, well, 33 hours. 3 of your 36 hours do need to be on the topic of license law. But you could take 33 hours, you could take 11 courses on contracts and still get credit. What you cannot get is credit for the same GREC course number. So it's not by topic, it's by course number. And that's every 12 months for a specific course number. And if you renew your license early, as soon as you pay GREC their money, your courses start back at 0. Let me give you a hint. If you are an experienced agent and your license is not due till the last day of the month of your birthday month, and you want to go ahead and pay them, but you feel like, let's say you wanted to pay them now, and you feel like you had a few more days to take a couple classes. They will, if you have not taken the law class, they will inactivate your license. So before you renew, even if you renew early, make sure that you have all of your CE credits, including your law. Now, because during the Zoom class, it does take a little bit longer to record the credits. So it takes us 3 to 5 business days to actually record the CE credits. We are not going to notify you once they are recorded. You guys, you can check your own file. Remember when you were in school and they said they had a permanent file on you? Well, you can check your own GREC permanent file yourself by going to GREC. Everybody has their own login on the GREC website. If you have not logged in since December 19th, they have changed their procedure, so you will have to create a new login and password. The other way to check your CE credits is your qualifying broker on their roster. We can log into our agent roster and look up any one agent to see what their CE credits are. All right, we are going to get started. So again, please, okay, everybody is muted. Please use the chat function to ask any questions. If we take more than 36 hours, no, the remaining hours do not carry over into your renewal. You would just be very well educated. All right, and I'm going to share my screen and we are going to get started. I'm going to make that small. I'm going to make that small. I'm going to move that over. Let me make that small. And let's get started. All right. One more thing is the handouts are available. You do not need them during this class, but they will be available to you. If you go to, and I just did it, I should have showed you guys what I did. If you go online and you go to www.eagentweb.com, and I'll give you this information again. If you click here where it says training videos, there's no password to get into any of this. If you click on training videos, you will click there. And as you scroll down through this page, you will see a variety of the CE classes that we have taught. This one, the 2020 RE Contract Forms Dissection. It's GREC number 71615. I am recording it, so the video recording will be soon, and I'll pop up the notice to students. These are all the handouts. There is a copy of the slides. It's not the PowerPoint presentation, but it's a PDF of the slides and all the handouts with underlines. So all you would have to do is click on one of these and you can download the PDFs for yourself. Again, you do not need them for the class in and of itself. I've got screenshots of everything. That is just for your reference after class if you want a copy of everything. All right, now let's start the slideshow. And here we go. All right, ready to get started, everybody? I hope so. All right, this is the 2020 RE Forms Contract Dissection. I am the instructor, Dana Sparks. I am the qualifying broker of Maximum One Greater Atlanta Realtors. And again, this is where you can get the downloads for your reference after class. The course is offered through the Georgia Real Estate Academy, which is GREC school number 6915. All right. The RE forms were actually born and copyrighted in 2012. They have done some major revisions in August 2014 and in 2015. One of the biggest revisions they did is they separated out the purchase and sale contract from the standard terms, and we'll go over that throughout the class. They did some minor revisions last year. The RE Forms Committee is continually adding forms to the library, but you're going to see a variety of copyright dates at the bottom of the various forms. Some are going to say 2012, 2014, so forth and so on. It depends on when that form was last revised. Now, the GAR, or Georgia Association of Realtor Forms, require, as part of their copyright, as part of their licensing agreement, that agents only use forms for the current year. So since we are now in 2020, if you are using a GAR form, it is against their licensing agreement to use any form that is dated prior to 2020. And GAR can take away your right to use their forms. However, that is not a licensing agreement for the RE forms. That is just a GAR issue. One other thing about these forms, there are teeny tiny little boxes that you have to check. So you absolutely need to pay attention and don't miss any of those boxes. And you'll see later when we get to the standard terms, it specifically says that any contingency or option shall only be granted if the appropriate box related thereto is checked within the body of the contract and selected by the parties. If the contingency is not selected, then it's not part of the contract. So that is such an important thing. So I'll point that out to you as we continue through the class and you see some of these forms. All right, wherever it is that you go to get your forms, whether that be through RDocs or Remind Docs through FMLS or Transaction Desk through Georgia MLS or any other programming through your MLS system, one of the documents that you can see is you can get an index of the forms. And there in that index of the RE forms, you can see it is organized by category. So you can see agency documents. These are all the agency documents. You can find all the disclosure documents and so forth and so on. So basically what that looks like is you're going to see the RE forms by category, and it's pages and pages. It's 4 pages of all of the forms. This handout again is available to you, and I have marked when the form, not when it was initially created, but any of the forms that were changed, the most recent changes, I have delineated on this document for you. Again, you get to see all of the forms. So if you're not quite sure what form you're looking for or the form number, that index by category is a handy document for you. All right, now the contract for the RE forms in 2015, they separated it out where you have the actual contract, which is called the Contract for the Purchase and Sale of Residential Real Property, and that is form RE 100. This is only a 5-page document, and it just describes the basic terms for the transfer of property. This is the 5 pages where you, quote unquote, fill in the blanks for the terms that get negotiated between the buyer and the seller. And it references the standard terms, but that standard terms document, which is RE1, in essence is all the legalese, or that's all the promises and consequences between the parties regarding what they had negotiated in the contract. So the contract in and of itself is 5 pages. The standard terms are 9 pages. So in essence, the entire document is a 14-page document. The standard terms are incorporated by reference, and the public can access these standard terms by going to www.reformsga.com. The consideration of the contract is contained in the standard forms. Now, as a point of practice, regardless of who holds your license, I strongly, strongly, strongly suggest that you print out these standard terms, attach them to the contract, and reference them as an exhibit. You guys have access to the standard terms wherever you access any of your contract forms. The public, this is where the public can access them, but you have access through, again, our docs, Remind Docs, Transaction Desk, so forth and so on. Some companies, for example, Maximum One, we have it as a policy that if parties go binding under the RE forms, the agents absolutely must include the standard terms as an exhibit as part of the contract. Again, you need to check with your broker on the policy, but as an independent contractor, it is definitely a good idea. All right, so in the actual, this is the actual contract itself. This is RE 100, the contract for purchase and sale of real property in Georgia. And you'll see, just like any other contract, you put in the offer date, you name the buyer, which is awesome, and you name the seller. I think that is a great thing on the first page of the contract to actually identify the buyer and the seller. But the next paragraph in all caps and bold says, this contract incorporates by reference those certain standard terms for the purchase and sale of Georgia real property published by Orthros Real Estate Enterprises, LLC at www.reformsga.com. Again, that's a public site where the public can go and pull down this document. And in effect, as of the offer date, the standard terms shall become a part hereof by reference. Each party, by affixing his or her signature hereto, meaning when they sign the offer or sign the contract, they expressly agree that they have read the standard terms and that it is in their own, that it is their intent that the standard terms shall be incorporated and are a part of the contract. Again, when they sign the contract, they're saying that they have gone online to this website, read through this 9-page document, and they agree that it's part. Again, point of practice, you guys just go ahead and attach it. All right, again, we are continuing on with the actual contract for purchase and sale. And the first thing is the property description. Now, obviously, you need a property address, but in Metro Georgia, you also need a legal description. And here's a place where you can fill out the legal description. You can attach an exhibit, which would be, for example, the warranty deed. That would be the best legal description. Or you can reference the deed book and page in the county, or you can fill out landlocked district section, Georgia militia district lot, so forth and so on. The issue is if you fill this option out and this is not complete, you do not have a complete legal description. But in Georgia, again, in Metro Atlanta especially, you absolutely need more than just an address. And I can prove it to you. How many Peachtree roads are there in Atlanta? More than one. Therefore, how many 1, 2, 3 Peachtree roads are there? Yes, there are more than one. So your legal description is going to help. All right, there is a question about the standard terms. I'm going to address that when we get to the actual document itself. If you don't know where to get a legal description, that you can go to the online county records. You can drive down to the courthouse of the county. You can ask your favorite closing attorney, or you can go to a website called www.gsccca.org. And that, let me see if I can write that here. That is a paid site where you can get copies of deeds and liens on the property. All right, then you fill in the purchase price. And in the RE Forms contract, you would fill this in words and in numbers. And that is great to avoid any sort of ambiguity or typographical errors. Most agents nowadays are typing up contracts on a computer, but every now and then you are hand writing them. And so, and even when you're typing, sometimes you could have a typographical error, but definitely This avoids ambiguity. Okay, so here's a pop quiz for you. If there is a discrepancy between a purchase price or a dollar amount that is written out in words and written out in numbers, which prevails? Words or the numbers? Words. Type it in the chat. Which prevails, words or numbers, if there's a discrepancy? Yep, you guys are correct. The words prevail if there is a difference between what is written here and what is typed in there. All right, earnest money. Now, this has a good faith deposit of, same thing, words and numbers for the amount of the earnest money. Shall be in the form of, see how teeny tiny these little check boxes are? They're not even in bold font. That is, it's very difficult to see. So you guys be extra careful and make sure that you are checking the appropriate box. I did not circle cash. You guys don't take cash, don't take cash, do not take cash, do not take cash, do not take cash. And then the earnest money, either the only way you're going to check this option, buyer has remitted the earnest money, that means you have the earnest money in hand when you are writing the offer. If you do not have the earnest money in your possession when you are taking the offer, then you are going to have to select this option, which says that the buyer shall remit the earnest money to the escrow agent, who is the holder of the earnest money, within, and the buyer and the seller negotiate the number of days from the RE forms uses the term acceptance, meaning binding agreement date, from the acceptance date of the contract, and then deposit them. So again, you're going to fill in the escrow agent, sorry, I skipped that, shall be payable to, and this is where you put in the name of the broker who is going to be the holder of the earnest money. If you put in a closing attorney, I want you to be extra careful about that. Generally speaking, our purchase and sale agreements here in Georgia are designed to have a broker, either the listing broker or the selling broker, as the holder of the earnest money. And the reason is your brokers, not only their individual licenses, but their firm licenses are also held to be accountable to license law. A closing attorney, if they don't have a real estate license, they obviously can't do anything illegal with the money, but they're not beholden to license law. And you will see nowhere on the purchase and sale agreement, and there are no exhibits in the RE forms for the closing attorney to sign and be a party of the purchase and sale agreement. So if you name a closing attorney as the holder of the earnest money, as the escrow agent, you're having your buyers give them a check or certified funds or money order for thousands and thousands of dollars with no agreement. The closing attorney doesn't sign this. The closing attorney doesn't have to do anything with those funds because they're not a party to the contract. All right, so you need to name the escrow agent. You need to fill in the form of the funds and the timing of when the buyer is to remit those funds. Now, pre-printed in the contract, it says the holder or the escrow agent, once they're in receipt of those funds, they must deposit those funds within 3 banking days. Now, look at this next section. It says, in the event said payment is not timely remitted. So what does that mean? That means that either the buyer has not sent in the earnest money, or it has bounced from the bank, or it's been marked NSF from the bank. Because if it's been marked NSF from the bank, that means that it has not been timely remitted because it is not in the possession of the escrow agent. So in the event, now let's say you're a listing agent. In the event said payment is not timely remitted, seller shall promptly be notified by the escrow agent, and the seller shall have the rights and remedies set out in this section. So don't you think the seller wants to know what their rights and remedies are if the buyer has not sent in the funds or the funds aren't being honored by the bank? Absolutely. The next section in the purchase and sale agreement is closing. Isn't that crazy? So if you are just using the purchase and sale agreement, let me show you a little bit about where this is. This will make a little bit more sense if you're actually looking at the document. So this is the contract for purchase and sale. And here's the section. I'm on page 1 of 5. Oh, also, I didn't put that in the slideshow. Your buyers and sellers, there's a place for them to initial at the bottom of every page. Earnest money. This is what we just went over. And then it says, if the funds are not timely remitted, the escrow agent notifies the seller. The seller shall have the rights and remedies set out in this section. We're on page 1 of 5. We go to page 2, and looky there, closing. A seller absolutely wants to know what their rights and remedies are. Well, guess where that part is all spelled out? Yep, you guessed it, in the standard terms. The standard terms, it explains here, the seller shall have the rights and remedies in the contract. Here's where all the rights and remedies are. And I'm going to go over that in depth when we actually get to this document. But I am just trying to illustrate to you guys the importance of not only using this 5-page purchase and sale agreement, but to absolutely not just rely on the public to go to this public website and read this standard terms document. But as a point of practice, you guys print out the standard terms, reference them as an exhibit, and attach them to the contract. Because information like this is all spelled out, and your public, you need to be able to demonstrate that you went over those issues with your public. The seller is definitely going to want to know what their rights and remedies are if the buyer has not made good on the earnest money. Same thing for the buyer. Is the buyer out of it? Is the buyer, what happens? All right, back to the slideshow. So again, the seller's rights and remedies, as I just went over, are filled out in the standard terms, and I'll go over that in depth when we get to that document. So now the next part in the actual contract is the closing and possession date. So you're just going to fill out, this is the date, this is the office, so this is the closing attorney that that gets selected to close this deal. At or in, that would be a city in Georgia. If the closing attorney is unacceptable to the buyer's lender or title insurance company, then, and you guys, you fill in the blank, this gets negotiated. Either buyer or seller have the right to select a different closing attorney. So right away, we know that if there is a loan involved, the closing attorney represents that mortgage lender. If there's no loan involved, or that mortgage lender, that closing attorney isn't acceptable by the lender, then you guys, you have to fill this in. Either the buyer or the seller has the right to select a different closing attorney. Then it talks about possession. Possession shall be, again, teeny tiny check boxes, either at closing or so many days after closing, and you fill in the time, or blank days before closing. If possession of the property is to be granted to the buyer on a date other than closing, the buyer and the seller should execute a separate occupancy agreement. And that would be a temporary occupancy agreement for the buyer prior to closing, which I strongly suggest you do not do, or for the seller after closing. But again, it's giving you guys a reminder that if the buyer and seller negotiate for any type of possession other than at closing, you really need to attach a separate occupancy agreement to the contract where they are going to negotiate through the terms of that. All right, so there's a requirement for the firm. Okay, basically, you guys, what I'm doing is I'm showing you what it is, what it looks like in the contract, since you guys don't have the forms in front of you. And then here's the discussion. Requirement for the closing date. You have to put in a closing date. You cannot leave that open-ended, or that does not demonstrate what's called a meeting of the minds for an enforceable contract for real property in Georgia. If you are going to extend the closing date, you must extend it by agreement on an amendment. For those of you that are familiar with the GAR contracts, The GAR contracts have a provision for an 8-day unilateral extension. Unilateral means only one party has to initiate the unilateral extension. Now, there are very specific reasons, but in the RE contract forms, if buyers and sellers are binding under that, there is no 8-day unilateral extension. They must be extended by amendment. Can you leave a blank for the buyer or seller picking another attorney? No, you need to have, because if that closing attorney is not acceptable to the lender, you need to negotiate which party has the right to select a closing attorney. You do not ever want to leave any blanks in the contract. And in this situation, NA would not be appropriate, because you have to have a closing attorney that's going to close the transaction. And if the one that is selected here, so in essence, this indicates that a buyer is selecting the closing attorney, or that just gets negotiated. But if that closing attorney is unavailable or unacceptable to the buyer's lender, you have to determine who is going to select the closing attorney. All right. So if there is occupancy after closing or before closing, you are going to use RE 255, which is occupancy for the seller after closing. Now, in this form, there is what's called a usage fee, meaning it has a place to negotiate where the seller pays the buyer for the privilege of staying in what's now the buyer's home for a certain number of days after closing. This usage fee is not part of the GAR exhibit that's also for the occupancy for the seller after closing. And there is a form RE 256 for occupancy for a buyer prior to closing. Again, really, really bad idea. All right, closing costs. This is where the seller's making a contribution to the buyer's closing costs. And in the RE forms, you fill out either a percent of the purchase price or a flat fee dollar amount. This is great if the buyer and seller are going to end up negotiating the amount of the purchase price. Then if you put a percentage here on the counter offer forms, you don't have to constantly counter not only sale price but closing costs, because this percentage is going to change as the buyer and seller negotiate through a new sale price. Now, in the RE Forms Purchase and Sale Agreement, there are 3 built-in contingencies into the contract in and of itself. This is wonderful because it protects especially a buyer, but it also protects you guys as the agents in case you miss a contingency. So the 3 contingencies that are built in to the Purchase and Sale Agreement are the buyer's general right to terminate, the appraisal contingency, and the financing contingency. So again, see these little teeny tiny check boxes? Even if you fill in the blank, so let's say this contingency shall expire at 11:59 p.m. on the day that is X number of days after the acceptance date. And a lot of times we're seeing 10, 12, 14, 7, whatever in the buyer and seller negotiate for this time frame, which is also in the industry known as the due diligence period. Those terms are interchangeable. Either the buyer's general right to terminate period or the due diligence period. Even if you fill in a number here, if you do not check this box, then the buyer does not have a general right to terminate. Same thing, here's the appraisal contingency. This contingency shall expire at 11:59 on the day that is X number of days after the acceptance date. Even if you fill in a number of days, you absolutely must check this box or there is no appraisal contingency for the buyer. And same thing for the financing contingency, X number of days, buyer and seller negotiate this from the acceptance date. Now, so because these contingencies are included in the purchase and sale agreement, you do not need any other exhibits except for financing. If a buyer is getting a government insured loan, an FHA insured loan, or a VA insured loan, you absolutely must include the FHA or VA exhibit. But if a buyer is just getting a conventional loan, no other exhibit is required. So now you're wondering, okay, let's say we check all three of these contingencies. And for example, let's say we put in, I don't know, 21 days appraisal contingency. Well, what happens if the property does not appraise for the sale price? Guess where the answer to that question is? Yep, you guessed it. All of that is elaborated on in that document called the standard terms. It talks about what happens if the property does not appraise for sale price. Who has termination rights? Are there negotiation rights? What is the seller's responsibility? What is the buyer's responsibility? If a party terminates because of a low appraisal, what happens to the earnest money? All of that is spelled out in the standard terms. Same thing with the financing contingency. If a buyer, yep, standard terms, you guys are doing great. If the buyer does not get a lender to approve of their financing, what happens? Again, all of those consequences of what happens if this, then what? All of that is spelled out in the standard terms. Again, I'm just trying to impress upon you guys how vital it is to actually include that document in the purchase and sale agreement rather than leave it up to the public to go to that public website and read it. Not only that, is your closing attorney going to go to that public website and read it? Probably not. Is the lender going to go to that public website and probably read it? Probably not. Hopefully they're reading the contracts, but I'm just gonna let that comment hang. All right, so the only additional documentation you need is if a buyer is getting a government insured loan. And an easy way to remember that is that when you think of government, I know that's a really loaded question right now, but when you think of government, I want you to think of extra paperwork, red tape, lots of paperwork, lots of paperwork, lots of paperwork. So FHA, Federal Housing Authority, and VA, Veterans Administration, those are government entities that are insuring these loans. When you think of a government entity insuring the loan, you need to remind yourself, okay, extra paperwork, extra paperwork. All right, where's my mouse? So again, and I'm going to go over these FHA and VA exhibits when we get to that part. All contingencies are subject to an expiration date of the contingency. A question about USDA. Yes, that is a government insured loan. Unfortunately, there is no USDA exhibit in the RE Forms library. I'm hoping that they will come up with one. So if your buyer is getting a USDA insured loan, you will want to get with your broker or your lender to be able to add some sort of verbiage regarding the USDA loan. You'll want to basically add a special stipulation that indicates that the buyer is pursuing a USDA loan. Okay. Now, this part gets a little bit confusing. There are a lot of agents in the marketplace that are using either the GAR, Georgia Association of Realtors Contract Forms, or the RE Forms, or a combination of both. So if you are writing an offer for a buyer on the RE Forms, again, we just said those contingencies are built into the purchase and sale agreement. The buyer's right to terminate, the appraisal contingency, and the financing contingency. In the GAR contract forms, the only contingency built into the purchase and sale agreement is what they call the due diligence period, which is the same contractual concept as a buyer's right to terminate period. But if a buyer is getting a loan or making the contract subject to an appraisal contingency or a financing contingency, in the GAR forms, that needs a separate exhibit. So the RE Forms has two separate exhibits. One is called the financing contingency exhibit, and one is called the appraisal contingency exhibit. If a buyer and seller go binding solely on the RE Forms contracts, You do not need these exhibits. The only reason these documents are in existence is if you write an offer on behalf of a buyer on the RE Forms contract. You submit it to a listing agent. A listing agent or the seller makes a counter offer to you on a GAR contract, but they either didn't read this thoroughly or they haven't taken this class on RE forms, and they don't understand, they don't see any separate exhibits for a financing contingency or an appraisal contingency. Don't let your buyer sign that GAR purchase and sale agreement without those contingencies in there. So if you don't have access to the GAR forms, you could then pull out the separate financing contingency exhibit and appraisal contingency exhibit and counter back to the seller again on behalf of the buyer to make sure that your buyer is protected on these contingencies. That's the only reason these forms are in existence, is if the counter offer process goes back and forth between forms. So continuing on with the actual purchase and sale agreement, it does have the financing contingency that we talked about. So you would mark this to make the contract subject to financing for the buyer. So if your buyer is just paying cash, all you do is not mark that. If you do not mark that box, then it is a cash offer without being subject to financing. Now, regardless if a buyer is getting FHA or VA or a USDA insured loan, you must fill out this information describing the first mortgage. So in the event finance contingency is selected, check all of the following that are applicable. First mortgage, and again, you're going to put in the principal amount, either a dollar amount or percent, and most likely this is going to be a percent of the purchase price, amortized over, and this is going to be like 30 years, 15 years, 20 years. And you need to check the box. Is it a fixed interest rate or is it adjustable? There's fixed, there's adjustable. And this is the percent of the interest rate. And then you fill out the information for the second mortgage. Again, okay, so here are the, let me mute everybody. All right, this is these are the actual exhibits that you would use if a buyer is getting an FHA insured loan or a VA insured loan. The FHA insured loan is RE 200 and the VA exhibit is RE 201. I believe I'm gonna go over these a little bit more in depth, but I just wanted you to see what they look like. All right, the next section, I am gonna go over these a little bit more in depth when we go over the standard terms. All right, the next section in the purchase and sale agreement is paragraph 7, where it talks about inspection of property. And Georgia is a caveat emptor state. Caveat emptor means, what does caveat emptor mean? Type it in the chat. Buyer beware, buyer beware, buyer beware, not sure. Yes. Caveat emptor is a Latin term that means buyer beware. And in Georgia, you guys, that is the law of the land for any purchase. And in essence, what that means is the legal burden is on the buyer to make themselves satisfied with what they are purchasing, whether that be goods or services or real property or personal property, prior to exchanging money for those goods or services. So the buyer is, in Georgia, generally speaking by the law, the buyer is responsible for checking out what it is they're purchasing before they buy it. There's no law that a seller has to take a return. Now, there are lots of policies where a lot of sellers will return. Now, not for real property, but if you go to a store or and buy something, there's a lot of retail stores that have a return policy, but that is not the law. So in the Georgia RE Forms contract, it states that the buyer has the right and the obligation with reasonable notice to the seller. So there is there is, you can't just, the seller still owns the home and lives in the home. You can't just barge into the seller's house at any time. So you have to let the seller know. But the buyer has the right and obligation to inspect the property, all improvements, for defects, other issues, including but not limited to AC, electrical, fireplace, lead-based paint, mold, plumbing, radon. It's just giving the buyer some ideas of things that they should check out. Wood-destroying organisms, environmental hazards, and other issues. Now, you guys are going to see later on when we get to the brokerage disclaimer in the contract, there's even more admonitions to a buyer and a seller what their duties are with respect to the RE Forms contract that they need to check out on their own to make sure that this property is acceptable to them. Then you negotiate that the buyer and their representatives for these inspection issues have from time to time after the date of acceptance or contract through and including closing from, and this has either 9 a.m. to 7 p.m. or you negotiate a different time frame. We're in the middle of daylight savings time right now, so we have a lot of daylight even after 7 p.m. So I always suggest that a buyer and seller might want to negotiate a different time frame during the summer months while we are in daylight savings time, because you have daylight till 8, sometimes 9 p.m. So you might want to change that, or you might want to leave it 7 p.m. So I just wanted to point out to your attention that in this contract form, there is a time frame that the buyer and seller negotiate for the buyer to have and their representatives to have a right to check out the property. Now, also for you listing agents, when you do have a Supra lockbox, you do know that you can change the hours of access on that lockbox. Then look at this. I should have underlined this. Utilities. In order to facilitate the inspection of the property, check one, and again, teeny tiny check boxes. Either the buyer or the seller shall make all required utilities operational and available through day of closing. So a lot of times you think, well, gosh, that's a seller's responsibility. And that may very well be, but if it is a vacant property or for whatever reason, the seller does not have the utilities operational, you want to make sure that the buyer and the seller negotiate whose responsibility that is to turn on those utilities. And it might be in a buyer's best interest to go ahead and turn them on so they can check it out and inspect the property. Okay, I'm getting a note in the chat. The Supra time frame is standard time, not daylight savings time. So you guys check that if you are changing the hours in your Supra lockbox. Then there is a charge to the buyers that they are responsible for checking out any neighborhood conditions affecting the property that would be a valid concern to the buyer. If it's a meth lab, if it's the sex offender registry, so forth and so on. All right, under agency, you guys, we are still talking about this 5-page purchase and sale agreement. Under this brokerage section, which is paragraph, oops, I'm gonna do that. Paragraph 8, it talks about you have to describe any sort of material relationship that the broker, this is the broker or you, the affiliated licensee, have with the buyer or the seller. So that would be somebody you know, a family member or a business partner or a past client. If you are working with a past client, that is a material relationship. So you would want to note that. And this is for you guys as agents to fill out either a material relationship with either the buyer or the seller. Then it also talks about the brokerage. You guys, you're all affiliated licensees with whom? The broker. All contracts are written in the name of whom? The broker. All that means not only purchase and sale agreements, but your listing agreements and your buyer brokerage agreements. So the agency relationship is created between the public person and the broker. Now, a public person can choose to work with you and your broker in a variety of capacities. They can choose to work with you as a client or a customer. Regardless of how the legal relationship gets defined between the public person and your broker with respect to the conveyance of a property, you need to mark that out, regardless if they are working So this says the buyer's broker identified on the signature page of this contract is the broker assisting the buyer, because we're on the buyer section, but it's the same verbiage on the seller, regardless of whether the buyer is a customer or a client. And so then you're going to mark either you are working with the buyer as a client by virtue of them having signed a buyer brokerage agreement, a customer, and you perform only ministerial acts, and they would sign the customer acknowledgement. Dual agent, let me see if I have this. Nope. I've got a YouTube channel called Real Estate Made Crystal Clear, and I just recorded a video on this exact topic. Basically, license law and Beretta require that if a public person is going to work with your broker as a client, they are required by law to sign a document that creates the client relationship. And that would be a buyer brokerage agreement for a buyer, a listing agreement for a seller. If a public person chooses to work with your broker as a customer, there is no law that requires they sign anything, but the RE forms have documents. There is a customer acknowledgement, and for the seller, it's the authorization to show property without a listing agreement. Those don't create the customer relationship, but they describe the customer relationship. You need to check with your broker on the policy. For example, at Maximum One, we have a policy that the public person must sign a document so they are in complete understanding of their relationship with the broker and with you guys as the agent. Good point of practice, not necessarily a policy. You need to check with your broker. And then dual agency, that means there's one broker, one agent, and that agent has a client relationship with both the buyer and the seller. It's not illegal as long as it is disclosed and both parties give their consent. Again, you need to check with your broker. There are a lot of brokers that have a policy against their agents having dual agency. And then designated agent, that means one broker, two agents, and each agent has a client relationship with their party. So one broker, and I've got two agents. One of my agents is working with the buyer as a client, and one of my agents is working with the seller as a client. And the reason that term came about, and the easy way to remember it, is the broker has designated agent A to work with the buyer and agent B to work with the seller. If it is a designated agency situation, then you must fill out which agent is working with the buyer and which agent is working with the seller. Now, a common mistake that we see in contracts is if you are working with a co-op agent, so your brokerage, let's say, is working with the buyer, and the listing is listed by a completely separate broker. You do not fill out the names of the agents involved in the contract in this section. This is just designated agency. The names of the agents working with the parties, if there are two brokers involved, that's all disclosed on the signature page. So this is you only fill in the agents' names if it is a designated agency situation. One broker, two agents, agents each have a client relationship with their parties. All right, next is a wire fraud disclaimer. You guys, wire fraud is a horrible, horrible issue in our industry. And basically this says that no broker shall email any type of wire instructions to the buyer or the seller. You guys, again, even if the earnest money is being wired to your broker, or even if you think you're being nice and want to share the wire instructions between the closing attorney and your parties, don't do it, don't do it, don't do it, don't do it. You may have liability if the public person's wire gets defrauded by bad guys. So don't email wire instructions, period. And that being said, if the if the earnest money is going to be wired, basically what's happening is brokers and a lot of closing attorneys are sending the wire instructions to the party via US mail. So if you are having a situation where the earnest money is being wired, you might want to negotiate for a longer time frame on that first section where it said buyer to remit earnest money to holder within X number of days. If you know it's going to be a wire, you might want to extend out that time frame to allow for the wire instructions to get to that party via US mail. Or you guys as agents, you might want to pick up the wire instructions from your broker and from your closing attorneys and have them with you so you can hand them to your buyers to avoid that sort of time frame. All right, there's a question. Agent working with a buyer and the seller is the sister of the agent and the sister is a FSBO. What type of relationship? Well, definitely a material relationship that you would have to disclose. Agent is working with the buyer and the seller and buyer, and the seller is the sister of the agent. And the sister is a FSBO. Okay, I'm not sure I quite understand it, but definitely that's a material relationship that you would disclose. In Georgia, the client relationship, let me go back a minute. The client relationship is contractually driven. So in terms of if it's dual agency or designated agency, or working with the client as one and working with the customer as the other, or working with both as a customer, that completely depends on what documents the buyer and the seller sign. Regardless of your personal, you definitely need to disclose the material relationship, but regardless of your personal knowledge of the public person with whom you are working, the only way a buyer is a client is if they sign a buyer brokerage agreement. The only way a seller is a client is if the seller signs a listing agreement. If the public people do not sign those documents, they are not clients with respect to this transaction. Again, regardless of your relationship or knowledge of them. Georgia, the client relationship is contractually driven, not relationship driven. All right. Now, again, you need to check with your broker. There's a lot of brokerages that have policies regarding not only dual agency, but working both sides of a contract. And again, I just did a whole long, it's actually a 30-minute video on having both sides of a contract and what documents need to be signed, what that means, how you fill out the contract, so forth and so on. All right, let's move on with the contract. Then the next section in the purchase and sale agreement is where you make a note of the exhibits. And again, I strongly suggest that you put here standard terms, mark the box, and then you write out the special stipulations. Exhibits are going to supersede a purchase and sale agreement, and special stipulations will supersede the exhibits. Therefore, this is Contracts 101. You do not want to use an exhibit for an issue that is already addressed in the purchase and sale agreement. And you do not want to write a special stipulation for an issue that is already addressed either in a contract or in an exhibit. There are some admonitions in the chat regarding some issues that go on with Transaction Desk. So y'all read those if you're using Transaction Desk. Now, what an example of this is what I just went over with the, for example, the appraisal contingency exhibit or the financing contingency exhibit. You do not use those exhibits if the parties are binding on the RE forms, because all of that information is contained in a combination of the contract and the standard terms. So if you use an exhibit for something that is already addressed in the purchase and sale agreement, and there's a conflict, you accidentally have something, for example, number of days or amounts or something like that, that's different in the exhibit is going to supersede the purchase and sale agreement. The RE forms has a special stipulations library that is 9 pages of special stipulations, and that is form RE10. And let me show you what that looks like. This is RE10, and again, there are 9 pages of special stipulations. So before you even consider writing your own special stipulation, please consult this library, RE10, because these special stipulations are written by attorneys, and they're going to have verbiage in there that you are not thinking of that will protect your clients. And if you handwrite a special stipulation, chances are you are not going to be protecting your client, whereas one of these special stips already authored by an attorney is going to have all the elements for contracts required and will protect your client. For example, here's about a home warranty. So a lot of times you guys will just put seller to buy a home warranty for the buyer, and that's all you put. Well, who's the home warranty by? What's the cost? When is it ordered? So for example, at time of closing, seller shall provide buyer home warranty issued by name of the company at a cost to the seller not to exceed X amount of dollars. The term of the home warranty shall be for at least 1 year from the date of closing, so forth and so on. So again, there are a lot of things that you are not going to consider when you're writing your own special stipulation that is already written out for you in these this library. So check out that. All right. Then on the last page of the purchase and sale agreement, we have a time limit and the binding agreement date. So here's the time limit, and here is where you fill in the binding agreement date. The time limit says this offer is open for acceptance until blank time on blank date. Open for acceptance means it is open with absolutely no changes. So if a buyer writes an offer to the seller and they sign it, they must sign it prior to this time frame on this date in order for it to be an accepted contract. If they sign it after this, or if they make a counter offer, it is a counter offer. So the time limit means open for acceptance with no changes. If there is a counter offer, so let's say the buyer writes an offer and the seller's going to make a counter anyway, they're going to change the sale price or the closing cost contribution or the date of closing or something. If there's a counter offer, then those terms that were offered were not accepted, and the time limit is of no consequence. This time limit is only for an acceptance with no changes. So if the seller is going to make a counter offer, or it can go back and forth. Let's say buyer writes an offer to the seller, seller writes a counter offer back to the buyer, buyer's going to write a counter offer back to the seller. So it doesn't matter which direction it is going in. If there is a counter offer, if there is a change in the terms that were presented, there's no time limit on that. A party can make a counter offer at any time. It can be prior to this time. It can be after this time. It doesn't matter. There's no time limit on a counter offer. In other words, the time limit is not a time frame for the response of the other party. It just means to accept those terms as offered with no changes. And then this paragraph is the RE Forms uses the term accepted contract. It is the same concept that most agents are taught in pre-license school, and throughout their brokers, we use the term binding agreement date. It's the same concept. And it says the offer is hereby accepted with notice in the form of an executed contract being properly delivered to the party making the last offer. So the party making the offer is the one that binds it. All right, so let me look at a couple questions. Is a friendship considered a material relationship? If you have to ask, then I would definitely suggest you fill that in as a material relationship. What do you do if you receive a contract from another agent and they try to write a special stip that is already written? Well, look at the special stipulation, see if it protects the party that you're representing, and you can always counter offer with a special stipulation from the actual library that is pre-written by an attorney. So after the counter, do we use the RE form acceptance date? So for example, if So back to what this says right here. If a buyer, let's say a buyer writes an offer to a seller and they put a time limit, let's say they put a time limit on it today of Tuesday, June 23rd at 11 a.m. Let's say it goes to the seller doesn't make any changes to the terms. They accept the price, they accept the closing costs, they accept the closing date, they accept everything, but they don't sign it and get it back to the buyer until 1 p.m. We do not have a binding agreement because those terms are only open for acceptance until 11 a.m. in my example today. If the seller signs it and sends it back at 1 p.m., what you have is not a binding contract, not an accepted contract. You have a counter offer. So then the buyer would then sign it, fill in the time, and send it. The buyer then signs it and fills it back to the seller. And then the time would be, let's say the seller sends it back at 1 p.m., the buyer signs it at 1:30 p.m., and then sends it back to the seller at 1:35 p.m. The actual acceptance date is 1:35 p.m. on that date, not the 11 a.m. on that date. It's a little technical, and in essence, for the timing of all of the other contingencies, you'll see the contingencies go till 11. We already addressed it. They go till 11:59 p.m. at night on X number of days. So the date is really the most important thing. But it's just important to know that it is a counter offer, not an accepted contract, if the seller agrees after whatever is written here, or if they make a counter offer. All right. Again, the acceptance date is critical to all timeframes within the contract. It does demonstrate a meeting of the minds, and it's not when the party signs it, but it's when all parties have specific knowledge that all the terms are accepted. There is an RE form called RE 265 that is notice of acceptance date. So in my last example, my confusing example where we went back and forth, I would definitely suggest that the parties execute this RE 265 notice of acceptance date so that everybody is on the same page, because all the other timeframes, especially with respect to the contingencies, are timed from that. Then, after we have that, we have this one little paragraph that says, again, we're referencing those standard terms. By initialing here, the parties acknowledge their receipt of a printed copy of the standard terms. Failure to initial this section shall indicate that the parties have declined a printed copy and hereby acknowledge the sufficiency of the online copy. So there was a question at the beginning of the class in the chat section that said, do you have your clients initial the standard terms? Because you'll see when we get to that document next, there is no initial or signature placed on that document. In essence, what this is saying is when the buyer and the seller initial here, they're saying that you have given them a printed copy. If they don't initial here, you haven't. I strongly suggest, with the technology that we have with eSign, you guys can always format a document where your party puts in an initial. I strongly suggest that you do actually create a fill in the blank for your parties to initial or sign the actual standard terms. And then you have the signature page where you fill in the name of the buyer and the seller. And it just has this little arrow, but that's where their actual signature goes, their contact information, and again, the brokerage information, including, this is required by license law, your license information, your license information and the broker's license number. And that can be the firm's license number, not necessarily the person that acts as your qualifying broker. If there is an agency relationship, then the brokerage information or your agent information is sufficient on the signature page. If you are working with a party that is a customer, then you need to fill in on the signature page either the customer's address or their email or their fax number. All right. Standard terms. let's go through a little bit of the standard terms. It's about 20 till 11. We started at 9:30. Let's go a little bit longer. Let's dive into the standard terms. I've got to talk a little bit faster, and then we'll take a break. So this is the document that is called the standard terms. This is RE1. And again, basically what this looks like is this is a 9-page document, and all of this information that I have underlined and highlighted is what I'm going to go through in the PowerPoint presentation. You have access to this actual underlined document where you can download copies of all the PDFs. This is where all that legalese is described for your buyer and seller. So it does say that these are incorporated by reference. This is not a standalone document, and it says it is not intended to be any kind of agreement between the buyer and the seller absent an executed contract. Oops, let me go back to the slideshow. The type of deed that gets conveyed is a limited warranty deed, and the title is good and marketable title. Good and marketable is defined, meaning the title insurance company will insure the title at its regular rates, subject only to standard exceptions. Now, remember we talked about what happens if the buyer either doesn't send the earnest money on time or the earnest money is not honored by the bank. What are the rights and remedies of the seller? Well, here's where they are spelled out. So what happens is the escrow agent has to send notice to the buyer and the seller that, look, we don't have the earnest money. We either didn't receive it or the bank didn't honor it, so it is not in our trust account. So in that situation, the buyer has 3 days, not 3 business days, but 3 calendar days to cure the default. In essence, the buyer is now in default of the contract, and the buyer has 3 days to make good on that money with the escrow agent. If the buyer does not do so, then the seller then has the right to unilaterally terminate the contract within 7 days after getting a note from the escrow agent that it has not been made good. Or this has to do with the seller's holding it, which is typically in new construction. Or the seller can say, you know what? We're going to go through with the rest of the contract. There's just no earnest money in the deal. Earnest money is not the consideration of the contract and is not required. So this happens a lot if you have a quick closing, or generally speaking, if there's a quick closing. So the seller can say, okay, I acknowledge there's no earnest money in the deal. We're still going to go to closing. And in that situation, the buyer, earnest money is kind of like layaway. They owe X amount of dollars at closing. They already have the amount of the earnest money on hold with the holder. So if they don't have any earnest money in the deal at closing, they just need to bring their full amount to closing. They don't have anything already on deposit. So again, days is calendar days. It's not banking days. The escrow agent must give notice that we don't have it. The buyer, again, has a time frame to cure, and the seller's option. The builder, if you're writing on new construction, the standard terms are used for new construction contracts as well. If it is a builder's construction deposit, it is not considered earnest money. It's considered a deposit, and it is not refundable. And that is all spelled out in the standard terms. Now, disbursement of earnest money, basically the holder, the escrow agent, if they're holding earnest money, if the contract is not accepted, they give it back to the buyer. If everything goes to closing as normal, it gets credited on the closing statement as a credit to the buyer. Or if the holder, the escrow agent, gets an order, a court order, or an order from an arbitrator, then the holder disperses the funds based on that court order. Now, if the closing, if it doesn't close, it fails to close for whatever reason, one of the other options of the holder is we can do what's called the 10-day letter. And I'll get into that in just a second. Or if it's too much money or too legally complicated, the escrow agent may also interplead the earnest money into a court. But all this part says the escrow agent can deduct all of our fees. If we have to interplead it into a court, a judge decides what happens to that money. but it costs money to hire an attorney to do that, and court costs to file those motions. We get to take our fees out of the amount of earnest money. And it also says when a buyer and a seller sign the contract, it says that they agree that the escrow agent is not liable for any loss, cost, or damage which may result as serving as escrow agent. So in other words, this says that a buyer and a seller can't sue the escrow agent for their decision to disperse the earnest money. Now, come on, you guys, let's be real. Anybody can sue anybody for anything. What this says is there are no legal grounds where the public is going to win that lawsuit. So they can always sue the holder, sue the broker, but chances are they are not going to win if it is just a situation where the escrow agent is acting as escrow agent. Now, if the escrow agent has committed fraud, they will probably win. But be very careful when you hear something in a contract that says they can't sue for this or can't sue for that. Anybody can sue anybody for anything, but this is the legal grounds under which their attorney is going to make the case if they're going to win or not win. So one of the other things, this is what happens more than not, is what we lovingly call the 10-day letter. So the contract doesn't close. If the contract doesn't close, then what happens is there's a termination, the contract gets terminated, and then there's an agreement to disperse the earnest money. And I have this information in the very end of the presentation. If the buyer and the seller agree on what the escrow agent is to do with the earnest money, the escrow agent just disperses the earnest money in accordance with the direction from the buyer and the seller. If the buyer and the seller don't agree in writing with signatures telling the escrow agent how to disperse the funds, one of the options available is the holder or the escrow agent gets to interpret the contract, figure out why didn't it close. And the party that did not come to closing, or the party that terminated the contract, did they terminate based on a contingency, and the seller just isn't agreeing, or the other party just isn't agreeing to disperse the earnest money? Did the party terminate by default? Did the party terminate based on a contingency, but that contingency had expired? Did they sign the termination prior to the expiration of the contingency, but the agent didn't send that termination notice to the other party prior to the expiration? There's all kinds of research that an escrow agent does to figure out why it didn't close, why it terminated, and contractually, was that based on something the parties had agreed to or not? Then the holder sends out a letter saying, I intend to disperse this earnest money to whichever party. I have to wait 10 days for the party not getting the earnest money to lobby a written objection. If that written objection is based on something in the contract, for example, let's say there was an amendment that was executed between the buyer and the seller, but I didn't have a copy of that in my files. So I could change my mind if it's based on something in a contract that I didn't have information about when first writing the interpretation. Or no, the party not getting the money is just complaining, but they're not entitled to the money per the contract. So I have to wait at least 10 days for any written signed objections. And then after that, the holder, the escrow agent, can disperse the money based on the notice, and they send a notice to the parties that they have dispersed the funds. All right. Moving on to closing. This is expenses related to closing. And again, the seller is responsible for any costs that are related to the seller being able to convey good and marketable title that is unencumbered without any liens. The buyer is responsible for all other costs and fees if not provided for in the contract, including but not limited to Georgia transfer tax, deed recording fees, so forth and so on. Now, let's talk about closing costs. So in the purchase and sale agreement, it was negotiated that, let's say it was negotiated that the seller is making a certain contribution to the buyer's closing costs, either percent of the sale price or a flat dollar amount. Well, what happens to that money? Well, this in the standard terms is where it's explained. The closing cost allowance agreed to by the seller, first of all, it's subject to any underwriting criteria of the lender for the buyer's loan. And it may be used for any purpose whatsoever to offset closing costs incurred by a buyer, such as title insurance, financing, HOA dues, so forth and so on, regardless if those costs are true, labeled as closing costs by the lender or not. Or it can be, those closing costs can be applied towards a buyer credit at closing, merely at the discretion of the buyer if needed to close the transaction. In essence, what this means is whatever amount of money that the seller has agreed to contribute towards the buyer gets the full advantage, gets the full use of that money at closing, whether they are used for quote unquote closing costs prepaid to escrows or anything else that can be used as a buyer credit on the closing statement. So nothing goes back to the seller. All right, now let's talk about the actual contingencies. So the buyer's right to terminate contingency is also known as the due diligence, the appraisal contingency. Now the time frame for the appraisal contingency was in the purchase and sale, but you'll see in the standard terms it talks about what happens if it doesn't appraise. For an FHA or VA insured loan, the appraisal contingency goes through date of closing, and you'll see in those exhibits control. So the buyer and seller cannot agree to a special stipulation to change this time frame to protect a buyer's earnest money if the property doesn't appraise. All right, so here's where it talks about the buyer's right to terminate. Okay, there's a question about the closing costs. If the parties are binding under the GAR contracts, this is not a GAR contract class, but in a GAR contract, the seller's contribution to a buyer's closing costs can only be used towards closing costs, prepaids, or escrows, and anything left over goes back as a credit to the seller. In the RE Forms contract, the buyer gets the full benefit of whatever the seller has agreed to. All right, this contingency shall only be granted by the seller if the appropriate box related to is checked. Remember I talked about those teeny tiny boxes? You have to check it. Even if you had filled in 10 days, if that box isn't checked, there's no due diligence for the buyer. And in essence, what this is exactly what it says. The seller gives the buyer the right to terminate for any or no contract. For any or no reason. So again, it must be checked to be included. The seller grants the buyer the right to terminate, and if they do so and send notice of that termination before that time frame, the buyer will get their earnest money back. The buyer can terminate for any or no reason, but they must do so and send notice. Now, also during this time frame, the buyer may ask the seller to address concerns with the property. If the seller does not agree to address doesn't agree to address any of those buyer concerns, the buyer either terminates the contract before the end of this period, or they accept the property as is. I'll show you that form a little bit later. Appraisal contingency. Again, this contingency shall only be granted if the appropriate box related is checked. So in the purchase and sale agreement, it just had the time frame. This contract is subject to the property appraising within X number of days from the acceptance date. Well, remember we asked, well, what happens if it doesn't appraise? Well, here in the standard terms, paragraph 6.2, it talks about what happens if the property does not appraise. And this is where it is all spelled out. And in essence, this seller gives the buyer the right to terminate with no penalty, meaning they're not going to lose their earnest money, if the appraisal is less than the contract sale price. The buyer or the seller has the right, but not the obligation, to propose an amendment to sell the property at the lower price. So, in essence, if the parties are binding under the RE forms, under a conventional, and the buyer's getting a conventional loan, the appraisal comes in less than sale price. The buyer can say, thanks, but no thanks, I'm terminating the contract, give me my earnest money back, I'm going on my merry way. Or the buyer can, or the seller can say, look, let's renegotiate this price. Let's sell the property for the appraised price. And they can agree to that. If the buyer does not terminate, or does not, the buyer and the seller don't negotiate by amendment for a different sale price, i.e. the lower appraised price, then the buyer is saying, okay, I agree to purchase the property per the contract anyway, regardless of the appraisal price. That would mean that a lender is going to only loan them money based on the appraisal value. But if you're under contract for hire, the buyer would have to bring cash for the difference. Now, the financing contingency. Remember, we filled that out in the purchase and sale agreement, making it subject to financing, and we had to fill out the terms of the first mortgage with the interest rate, the down payment, if it's a fixed rate or adjustable rate, 30 years, 20 years, 15 years, so forth and so on. Now, what happens, however, if the buyer cannot convince the lender to lend them the money? Well, the buyer would have to terminate prior to the end of that time frame that we negotiated in the purchase and sale agreement. But they have to not only terminate, they have to terminate and they have to prove it. They prove it with a loan denial letter from the lender. So the seller gives the buyer the right to terminate the contract with no penalty if the buyer can't secure a loan under the terms defined in the contract. However, if a buyer is going to terminate, meaning they can't convince a lender to lend them the money as described in the what we filled out under the first mortgage, then the buyer must send notice of termination and prove it with a loan denial letter from the lender. And they have to send those simultaneously prior to whatever that time frame was negotiated, X number of days from the acceptance date. Now, this loan denial letter, though, is very specific. It cannot be based on sufficient funds for the down payment. I'm sorry, that should be insufficient. Insufficient funds for the down payment and closing costs. Failure to sell or lease existing property without this agreed upon contingency, or the buyer's conduct after acceptance but prior to contingency. In other words, the buyer's not going to get their loan. They get a loan denial letter from the lender, but on the loan denial letter, it says buyer doesn't have down payment. They do not meet the terms of this financing contingency. So no, they're going to have to terminate the contract and not be able to buy the contract, but they are not going to protect their earnest money because they're not meeting the terms of this contingency. Now, this other thing, this right here, this is an interesting one where it says buyer's conduct after acceptance, but prior to contingency, to this contingency. What that means is a lender is going to pull your buyer's credit when they go under contract, and then your buyer gets all excited and they go to a furniture store and buy a whole house full of furniture because they misunderstood the ad that said same as cash, or they go buy a car, or so forth and so on. That is evidence of their conduct after acceptance, but before this contingency. So let's say they buy a house full of furniture, or buy a car or something, and it affects their credit negatively. And now when the lender goes to re-pull their credit and it no longer meets the underwriting guidelines for that lender, the lender is going to terminate, is going to deny their loan, but it's because of a negative change in their credit because of their conduct. The buyer is not going to be able to close, but the buyer is not going to protect their earnest money. That is what all of that means. All right. So because the buyer not having down payment money or money for closing costs does not meet the terms of the financing contingency, if you are working with a buyer who is applying for down payment assistance funds from Georgia Dream or any of those other grant programs, I strongly suggest that you use this special stipulation to protect the buyer, because in and of themselves, if the buyer gets turned down for those down payment assistance funds, they're going to lose their earnest money because it doesn't meet the financing contingency. However, if you use this special stipulation in the purchase and sale agreement, it says this agreement is contingent upon the buyer's approval for the receipt of down payment from X program, and that would be Georgia Dream or whatever program the buyer is seeking their down payment assistance from within X number of days of binding agreement date. Should the buyer not be approved for the down payment assistance program within this time frame, the buyer may terminate without penalty if the buyer notifies the seller in writing and provide the DPA denial letter. Again, if you're working with the buyer getting down payment assistance funds, you've got to put this special stipulation in there making this contract subject to not only them getting financing from the bank for the rest of the mortgage, but to get their down payment assistance funds. In those documents that you guys can download after the class, I do have a PDF of these slides. So you will get this verbiage in that, or I'll leave it up for just a second and you can pull out your phone and take a picture. All right. Now, again, financing contingency for FHA, VA, and USDA. And it's interesting because it does say USDA, that you must use those exhibits. The provisions in those exhibits must prevail. Again, there is no USDA exhibit, so hopefully the RE Forms Committee will come up with one fairly soon. So let's talk a little bit. Let me see if I have a next. Yep. Let's talk just a little bit about some of the differences if a buyer's getting an FHA insured loan or a VA insured loan. Again, this, I've already addressed this financing contingency exhibit, you're not going to use it when you're binding on the RE forms. It's only for the switcheroo. And yes, this special stipulation does say binding agreement date. You can use the term acceptance date. This is also a great stip to use for the situation if you go binding under the GAR contracts as well, because the same provisions for the finance contingency is for the loan denial letter is in the GAR contracts too. So you can change that to acceptance date. All right. Now, briefly, we're going to go over the FHA loan contingency exhibit. The FHA loan contingency exhibit and the VA loan contingency exhibit have the appraisal contingency built in. So remember what we said earlier, an exhibit supersedes the purchase and sale agreement, right? So if a buyer's getting an FHA loan, you must include this exhibit. So in the purchase and sale agreement, let's say you put, you just weren't kind of thinking straight and you put appraisal contingency 21 days from acceptance date. Well, when you use the FHA loan exhibit, the appraisal contingency is built in and the exhibit supersedes the purchase and sale. So it does say this exhibit shall control over any conflicting language in the contract or any exhibits or addenda. And in essence, the buyer this is the appraisal contingency paragraph. It's the first paragraph in this exhibit. The buyer shall not be obligated to complete the purchase or incur any penalty by forfeiture of earnest money if, in essence, the FHA does not appraise the property for, and you need to fill in the sale price right there. When there is a fill in the blank and there is a dollar sign, that calls for numerals, not words. So you have to fill in the amount, and if that gets countered, remember to counter it with respect to the FHA loan in a counter offer. And again, there's no time frame here, so it would go through day of closing. On the FHA loan exhibit, you also have a place to fill in the mortgage insurance premium, and typically it's added to the buyer's loan, and get this information from the lender with whom the buyer is working. Now let's talk about seller costs. If a buyer is getting, I'm going to go through FHA and VA loan exhibit, then we'll take a break. If the buyer is getting an FHA insured loan and the FHA commitment identifies any repairs, that means the appraisal, if there's any repairs that come across mandated by the FHA appraisal, the buyer and seller negotiate this dollar amount. So we have repairs, we have if it is required by the FHA that the property be connected to public water or sewer, and we have if there are any lender required septic tank or well inspections. And basically what that whole paragraph states is you fill in the blank, you negotiate the amount. If, however, the actual repair costs, this isn't repairs negotiated on an amendment to address concerns. This is repairs mandated by the FHA appraiser. If those costs are more than what was negotiated in this fill in the blank dollar amount right there, then the seller is not obligated. The seller can pay for those to get the house sold and get it done, but the seller is not obligated to complete those repairs if that cost is more than that amount, and the seller can terminate and the buyer will get their earnest money back. Other seller costs are tax service fee. If the seller had agreed to contribute to the buyer's closing costs, that tax service fee is taken out of those closing costs. If the FHA mandates that the property be connected to public water and sewer, again, on this exhibit, you negotiate a dollar amount for that. If the connection costs are more, the seller is not obligated and may terminate, and the buyer gets the earnest money back. And the seller is obligated to pay for a septic or well inspection if it is required by the lender. So those are some things that you listing agents, you need to have a discussion with your seller about additional costs that would be incurred to them if a buyer is getting an FHA insured loan. Then on the FHA loan exhibit, there's a few more other declarations and disclosures, and you need to address if it is an arm's length transaction. Arm's length transaction in essence means no basically no material relationship, not between you and the party, but no material relationship in essence between the buyer and the seller. All right, VA loan exhibit, same thing, the appraisal contingency. Well, let me back up. First thing, the VA loan exhibit controls over any conflicting language in the contract or other exhibits or addenda. And the buyer, here's the appraisal. First paragraph is the appraisal contingency for a buyer getting a VA loan. If the property does not appraise for the sale price, the buyer shall not incur any penalty by forfeiture of earnest money and not be obligated to purchase the contract. There's no fill in the blank for a sale price like there is on the FHA exhibit. So basically it must appraise for sale price. If it appraises for anything less than sale price, the buyer may terminate and get their earnest money back, and the time frame goes through day of closing. The next section is it talks about the VA funding fee, and you fill in at closing, buyer or seller will be responsible for full payment. Usually we see buyer, or the buyer has other options. They can either include it into their loan, or it may not be required. You'll have to check with your veteran, again, this is a VA loan, to determine, they will know, or they need to check with the VA to see if they do have their VA funding fee eligibility still available to them. Then now under the VA loan exhibit, there are seller costs. So if a seller accepts a contract and a buyer is getting a VA insured loan, there are absolutely some costs incurred by the seller. So you fill in all the blanks. Again, we've got repairs. We've got, this is a general statement. We've got, again, public water and sewer, and we've got a lender required septic or well inspection. So basically what this says, repairs required by the lender, a negotiated amount. If the repairs are more, the seller is not obligated, may terminate, buyer gets earnest money back. In a VA loan, as opposed to an FHA loan, there is a general statement that there are certain costs a VA borrower is not allowed to pay. Costs associated with closing a VA loan that the buyer may not pay. Those are included in any seller's contribution to closing costs. I should have put it on this slide, but I didn't. In a VA insured loan, it is absolutely required that a seller provide a termite clearance letter dated within, it's either 30 or 60 days of closing. That is one of these costs associated with a VA loan. So if you're a listing agent working with a seller, you negotiate a contract and the buyer's getting a VA loan, just know that the seller is going to have to provide a termite clearance letter. Again, connection for public water and sewer, if it's more, the seller's not obligated, and same thing with the septic or well tank. Okay, on FHA or VA, how do you come up with a price for repairs and cost to connect public water and sewer? So for repairs, generally the VA and the FHA appraiser look for repair issues that are safety hazards. They're not looking at repair issues like an independent home inspector would. They're looking for cracked glass, rickety stairs, things where in essence the FHA or VA appraiser could be sued by not pointing out those safety issues and a buyer buys the house. So when you're listing, when you are a buyer's agent walking through a house and you notice those things, there's not a set amount for repairs. It depends on what the issues are, and it depends on the sale price of the house. I strongly suggest that you get with a general contractor or Google average price for repairs for these issues in your area, and you can look at things. I forgot, there's a source. I can't think of what it is. One of you guys might think of it and type it in the chat. Similar to an Angie's List thing, but there is a source where you can go online and sort of get an estimate in the metro area. You put in the name of the city where you're looking, and it kind of gives you an idea of general cost of those repairs. For public water and sewer, I can tell you that the time frame within which I have been a broker, which has been since, well, I've had my broker's license for a long time, but I've been a broker 12, wow, about 12 years now. I cannot recall a VA or an FHA contract where the lender in Metro Atlanta, where the lender did actually mandate that public water or sewer be connected. The cost for that is in the thousands, because there's connection costs to run piping from the street to the house, much less convert the connections within the house. So as far as an amount for that, I cannot, it's going to be in the thousands, but I can't even recall a contract where that has been Home Advisor. It might be Home Advisor. Again, even if you can't find Home Advisor, I think if you Google average repair costs for whatever those issues are. Does a VA or FHA loan need a special type of property inspector? No. I say no. You might have your buyers talk to some independent home inspectors who might have more knowledge or specialize in FHA or VA insured loans, but I don't know. That's not anything. They could use just any home inspector that is well versed. All right, I've got 11:15. So let's do this. Let's take a break and let's come back at at 11:30 a.m. And so be back at 11:30 and we will start back. When you come back, please type in again your name, email address, Georgia real estate license number, and if you are attending this class via telephone, please type in your phone number as well. I am going to leave this slide up just for a second. I am going to stay here and answer questions. You can either type them in the chat or you can unmute yourself and ask me a question. So be back at 11:30. Don't turn off your computer, but be back at 11:30. And I'm going to go ahead and stop sharing the screen. All right. And again, I'll be more than happy to answer any questions anybody has. One in Conyers that did require sewer and well connection. That's interesting. How much did it cost, Christy? Do you know? All right, I'm going to put myself on mute.
Hi, can you get
and the Georgia Superior Clerk of Courts Co-op Association.org. It is a co-op of the Metro Atlanta Superior Clerk of Courts. I don't think it has everyone, but it has a lot of the Metro Atlanta ones where you can look up not only warranty deeds, but you can look up lien information as well. It might be paid. You might have to pay for a subscription. I don't know the cost because I know at Maximum One we provide it, we pay for it and provide it for our agents. So I'm not sure what other brokers do, and I don't know actually what the cost is. All right, here is another question. Oops. License renews July 13th, 36 hours, renewed 2 weeks ago, hours reset to 0, 2024. Yes, so this class will count as, Michael, this count will count towards your 2024 renewal. I think it should. Any other questions? So
Yeah, can you hear me?
yes, I can hear you.
Okay, I was trying to go to FMLS, but I don't have enough time. Earlier, you mentioned with that offer time limit, once the person, the buyer or the seller signs it after the time limit, like 11 a.m., they sign it at 1 o'clock, and it's considered a counter offer.
Correct.
Doesn't RE has a counter offer form contract? Don't we have to put it on that one? Because if the buyer signs it on the actual document and it's called a counter offer, it may not. I know God got a counter offer special.
So yes, the time limit is one of the most misunderstood concepts in real estate, even among the most experienced agents. A lot of agents in general believe that the time limit on a purchase and sale offer or a counter offer means that is the time frame within which the other party is has to respond. It has nothing to do with response. It means these terms are open for acceptance without change until that time. After that, it's off the table. It's no longer an offer. So if the buyer or a seller, if you're going back and forth, but if a buyer writes an offer to a seller, the seller doesn't change anything, but they don't sign it and send back notice of acceptance until after the time frame, well, that offer's been pulled off the table. So in essence, it's a counter offer. It's as if the seller wrote up all those terms and presented it to the buyer. So it just has that verbiage that we went over because contractually it is a counter offer. So no, you would not. I love the way you're thinking, and you were thinking contractually, and that's awesome. But the problem is you're not going to take the time to rewrite all of that stuff. So, but contractually, in essence, it is a counteroffer. So all you would do is use that RE form, and I'd have to go back and look up the number, but you would use that RE form that is the notice of acceptance date, because the acceptance date is going to be, it is a counteroffer. So then basically what happens is, okay, it's a little bit complicated. Let's say you had a time limit and the seller signs it and fills it. Let's say the time limit was 11 a.m. The seller fills in the acceptance date at 1 p.m. Well, it's not an accepted contract at that point. In essence, what you could do is you could have the seller initial that 1 p.m., send it back to the buyer, and then the buyer, it's now an actual bound or accepted contract at that time. Again, it gets very confusing. They just have it in there because it's not open for acceptance. Another way of doing that is, like I said, with that form,
Notice, yeah.
Down here, which is notice of acceptance date, which is an RE form. I'm going to look it up in just a second. If that helps. So I love the way that you're thinking about writing all that stuff up in a counteroffer, but in practicality, that's not going to happen. All right, let me look.
It's time consuming.
It's very time consuming, and there could be some mistakes made accidentally. But there is a counteroffer form. All right, let me look up.
I like the first document you showed us was all these RE form thing. I took a screenshot of it, RE file 150, but it doesn't have notice or purchase and sale numbers on there.
So it does. The the notice
RE 100. Yeah.
The contract is RE 100 and the standard terms are RE 1. The notice of acceptance date is RE 265.
Okay, they don't show. When I took a screenshot, it started from 150 to 161 and 130 to 148 for some reason. RE4, I guess. So indexed by category. Yeah.
If you actually pull up that document, or if you go to eagentweb.com and you download I've got that as a PDF that you can download, and you'll see the full document where it does have the form number also. So that should help you.
So you said eAgent?
So can you see the chat screen?
Yes, I don't see anything. Yeah, hold on.
So in the middle, I have handouts you may download after class, may be found at www.
eagentweb.com. Yeah, I see it.
Yeah, and then you're going to
.com.
click on training videos, and then you'll find all the documents to download, including a PDF of the PowerPoint slides.
Videos of PowerPoint slides. One more question, slides. There was a YouTube channel that you mentioned that says real estate made clear or something.
Yes, I have a YouTube channel, obviously for GREC marketing license laws. I have to put maximum 1, but my YouTube channel is called Real Estate Made Crystal Clear.
Okay, real estate made crystal clear.
And I do have something specific to maximum 1 agents, but basically the intent of that channel is I go over all sorts of contractual issues here in Georgia regarding the GAR contract forms and the RE forms. And when I, generally speaking, when I put up videos on that site, my audience is all real estate agents in the state of Georgia, regardless of who your broker is. I always say that you always need to check with your broker, confer with your broker on any specific contract issues. But I've got 4 or 5 years worth of contract tips on that channel, and I have playlists where you can look up various videos by category. For example, the GAR forms or the RE forms, or repair issues, or earnest money, or license law, so forth and so on. So yeah, check it out. Love for you to subscribe. Again, it is years and years worth of contract tips. The audience, the intended audience, generally speaking, are real estate agents in Georgia, and it is specific to license law and the GAR forms and the RE forms, as well as there are a few lead generation tips and points of practice and things like that. For example, the one I just recorded yesterday and will be posting soon is all you need to know about having both sides of a deal. And there's one that just came out this morning. I don't remember what it was because I recorded it the other day. But usually the videos that I post have to do with issues that generally speaking, Georgia agents are experiencing. The one I put up today is, it's a fast market in Metro Atlanta, tips for real estate agents. So in essence, right now, you guys, we are in what would be considered a fast market or a seller's market. And so in the video that just came out this morning, I have all kinds of not only discussions, contracts that you should use, and license law that you need to be aware of when interacting with a buyer and a seller regarding how to proceed in this quote unquote seller's market. You guys, there are a lot of buyers and sellers out there. They're in Metro Atlanta. Now, again, this does vary by price range and area, but generally speaking, there is more demand than there is supply. So generally speaking, there are more buyers that are looking for properties than there are sellers right now putting their homes on the market. So great topic of discussion for you guys to have with some listing prospects, that there's buyers ready, willing, and able to buy their homes. Interest rates are extremely low as well.
Okay, I appreciate you, but one more thing. I'm going to check out your. I'm a general contractor. I used to be a general contractor. I'm a contractor and investor. I got some rental properties, and I took just for the heck of it, and it's great because I took my license back in 2000. I've been licensed since 2000, almost 20 years. And then I decided 6 years ago to get my broker license.
Okay.
But I'm pretty good. I'm very good at multiple choices, but all of a sudden they changed it to simulation class. And I took some, I really studied hard and everything. I thought I passed, and I think their office, the professional, something off of Beaver Road, they deal with Tennessee. They never gave me my score. Now, before you sit for the broker class, you have to take a state class. And I passed all that 200 multiple question at the Montreal Road, Georgia GMLS office. And that's what originally I got my license. So you have to take a state class before you take your broker class. I passed that, no problem. But then for some reason, and I told them, look, I need my score. They never sent it to me. But then how does maximum one helps me get my broker license? Because I think it's still simulation classes, right? For brokers.
So generally speaking, any classes that you take, either for CE credit or to get, obviously I don't know if it's obvious or not, but I imagine all of you guys have at least a salesperson's license. You have to be an active salesperson for 3 years before you can sit for your broker test. And then you have to take I believe it's a 60-hour class, broker pre-license. And then just like salesperson, you have to pass the broker test, the school test, and then you're eligible to sit for the state broker's license test. So those kind of questions aren't really for any one brokerage. That would be a school question. I know the Georgia Real Estate Academy right now does not offer any sort of broker pre-license classes. We offer salesperson's pre-license classes, but we currently do not have any broker pre-license classes available or any CREAM courses. They did change the broker test from a multiple choice test to a situational test. So I would suggest that you check out other real estate schools that offer broker pre-license school. And what you might want to look for would be a broker pre-license. It sounds weird because it's pre-license, but it's broker pre-license, not salesperson's pre-license. You might want to check out a broker pre-license CRAM course. And there's a ton of real estate schools that you could Google online. There's some online courses as well as some actual schools with a physical location. I'm not sure right now what schools are having virtual classes or having actual in-classroom classes right now.
Oh, okay, thank you. But to just let you know, FYI, I'm currently licensed, and I took that broker pre-license. I don't know what the wording was, but that's the class that I took, and I passed the broker pre-license CRAM course. So,
awesome.
Okay, thank you.
Yep, you're welcome. All right, back to the connection fee. Thank you, Christy. There was yeah, the connection, like I said, you had that situation where in Conyers, the lender did mandate the connection to public sewer and water. And yeah, it is so high. It is in the thousands of dollars because what Christy has put in the chat is the connection fee for the connection to the well was so high because it included not only pipe being dug, you have to run the line from the street to the property. And then if you're converting from, a well or even septic to sewer, there's all sorts of other work that has to be done. And generally speaking, it is going to be cost prohibitive for an actual contract. Generally speaking, there obviously are situations where a buyer and a seller would negotiate that, or a seller might choose to switch it over. But yeah, and I've never even seen that on a contract that we've had going on. All right. Any other questions? All right. I just put again, type in your name, email address, Georgia real estate license number. If you are attending via phone, we need your phone number as well. Again, thank you guys. It's very different teaching virtually versus teaching in class. I get a lot more interactions and there's a lot more questions that I ask of you guys when we are actually in a classroom setting. I'm really excited that all of you guys are on this. The RE forms are not going anywhere. There are a variety of real estate forms that agents have access to help their buyers and sellers in Metro Atlanta. There's the Georgia Association of Realtors forms. There's the RE forms. There's HUD contract forms. There's new construction forms. There's investor forms. There's attorney written forms. So it's not that this is the only alternative form. For years and years, there have been a variety, like I said, of contract forms that agents fill in to help their buyers and sellers. The issue came about because you have to, as a real estate agent licensed in Georgia, you have to pay the Georgia Association of Realtors an annual fee to be able to be licensed to use their forms, whether you pay that fee in the form of dues money to a local board, or you pay them a fee to just use the license. So there are a lot of brokers that want to be able to, back in 2012, when GAR first started charging for the use of their contracts, there were a lot of brokers and FMLS and Georgia MLS got together to be able to provide a valid contract form for their agents to use with their buyers and sellers that would not incur a fee to use. So that was the reason for the birth of the RE forms. And so the two sets of forms that the majority of agents have readily available access to initiate an offer is either the GAR forms, if you have paid for that one way or the other, or the RE forms, which there is no charge for. So they're not going away anytime soon. I am so excited for all of you guys on this class for a variety of reasons. Number one, just to learn about them. And number two, there are some things regarding the RE forms that might be more preferential for your client versus another contract form. Or if you are an agent and you're more familiar with one of the other contract forms and you receive an offer on an RE form, now you can negotiate either on this form or with a counter offer or so forth and so on. So firm believer in training and education is by far an issue or a concept that helps not only you guys as individual agents, but it helps brokers, it helps our public buyers, our public sellers, and it helps our industry as a whole. I teach another class, we offer another class through the Georgia Real Estate Academy, and I teach it, and it is called the 2020 Contracts Review. And that is a direct head-to-head comparison and contrast between the 2020 GAR contract forms and the 2020 RE forms. We don't go through the forms like this. I'm kind of going through everything paragraph by paragraph. It is not a line-by-line contracts class. It is a direct comparison of the similarities and the differences between the GAR contract form and the RE form. And that's another whole 3-hour plus class. So the purpose of this class, again, is just to go over more specific information to make you more familiar with this contract form. So I am going to get back started, and hang on one second. Can you give some situations when the RE form is better than the no, I'm not, that's not the purpose of this class. I appreciate the question about one better, one worse. Again, that is a whole nother 3 hours of comparison and contrast. I believe I might be teaching that class in July. The Georgia Real Estate Academy is working on our July calendar as we speak. We hope to have that finalized by the end of the week. And I believe I'm teaching that again. It's called 2020 Contracts Review, GAR versus RE. So I'm not going to give an example here in this class. That's not the purpose of this class. And again, there's a gazillion, 3 hours plus worth situation. So I appreciate the question. All right. For the course evaluation, I am going to launch a poll. And the poll is the course evaluation. And there are 5 questions. At the bottom of the poll, you will see a submit button. That button doesn't work until you scroll down and answer all 5 questions. Once I launch the poll, I cannot relaunch it. So in the past, teaching these Zoom classes, we have had some issues. If you have issues, that's fine. If you don't have issues, we greatly appreciate your filling out the 5 CE course evaluation questions. Again, you do have to scroll all the way through. On the very far right-hand side, you will see a little thin line that will help you scroll through before you have the submit button. And before I launch that, I am going to mute everybody again, and we go till, got an hour. All right, got an hour to knock out the rest. And let me make that small, and I'm going to launch the poll. All right, you should see the poll. And again, on the far right-hand side, you see a gray bar that will help you. You have to scroll down and answer all 5 questions. And then that submit button will light up and you can hit submit and submit it. So I'm going to leave that up through the end of class. All right. Again, it takes 3 to 5 business days for these CE credits to be recorded because teaching a virtual class, there's a bunch of reports we have to put together as well as the chat. All right, give me 1 second. And we're going to get started and knock out the rest. Heidi, I just put my information in there because I just renewed my license yesterday. And so I too am going to start on credit for my next 4 years. All right, share the screen. We are going to go back and we're going to continue. Oops. All right. All right, everybody, we are continuing on with the terms of the standard terms. Again, this is why this document is so important. This is where all the legalese, all the responsibilities, all the duties, all the consequences of a party not doing what they said they were going to do, all of that is spelled out in this non-page document. So continuing on with this, we are on paragraph 7, condition of property. And again, we address this a little bit in the actual contract, but it is more thoroughly explained in the standard terms. And it does say that, remember we talked about Georgia's a caveat emptor state? Well, that puts the burden on the buyer. But in the purchase and sale contract, it also puts a duty on the seller, which is a great thing for you agents and for your brokers. It says seller and buyer have been advised and expressly acknowledge their obligation to conduct a thorough investigation or to obtain independent professional advice with respect to any concerns they may have regarding the contract or the condition of the property and the surrounding neighborhood. And then it goes on to give a bunch of suggestions to direct their thinking. Structural issues, safety issues, title issues, environmental issues, financial tax. It has this on here. This is really directed towards a seller. Well, it could be directed towards a buyer too. If the seller says, hey, when I bought this property 5 years ago or 3 years ago, my agent told me that it was a good investment and I was going to net X amount of dollars. Well, this is up to a seller or a buyer if you have a buyer looking at it for an investment. This does not fall back on the shoulders of an agent or a broker. That's why we have seller in here too, as well as some title issues. And again, we talk about zoning. I got a call yesterday from an agent, buyer and seller under contract, and they haven't closed yet, but the buyer is outside of all of their contingencies. The buyer just found out from an article that was printed in the newspaper, or they found an article online, that the zoning of that area, not the zoning, but the Department of Transportation is getting ready to widen the road. And guess where that widening is going to happen? Yep, the guy's front yard of the house he has the purchase and sale agreement on. So it is I believe it was a change in zoning, and it is a matter of public record. Now, the question was, the seller had knowledge of it because apparently the seller went to a meeting about this back in November. Maybe why the seller's selling the house, who knows? So what the question was, whose responsibility was it to disclose, and can the buyer terminate the contract without penalty? And in essence, it goes back, and is the agent responsible? Does the agent have any liability? Well, the agent does not have any liability because of this issue. It is the buyer's and the seller's duty to check out everything with respect to the purchase and sale agreement and everything that would happen before proceeding, looking out for their own best interest. This, in essence, would fall into a buyer's responsibility during their buyer's right to terminate time. They had a duty to check out the area, including the zoning of what's going on in the neighborhood and in the area. Now, what about the seller's duty to disclose it? Well, it's not a latent material defect regarding the property. It's not latent because the buyer, it was out there as public record, and the buyer had the the buyer could have inspected or checked that out. So very unfortunate situation, but in essence, per the contract, the buyer, the responsibility would have fallen on the buyer. So I don't know what happened. What the agents were going to talk about is having the buyer does not want the property at this point. So they were talking about the buyers terminating, but the buyer and the seller negotiating that earnest money to be split between them. Don't know what happened, just took that call yesterday. All right. This is also true with surveys. We're having a lot of issues lately with surveys. The buyer needs to get a survey of the property if their borders or their property line is important to them. They cannot go by what they think the property is or what it looks like. All right, there is let's talk about repairs. This again is in the standard terms in paragraph, sorry about that, in paragraph 7.3, where it's talking about that the standard terms are used for a variety of purchase and sale agreements in the RE forms for resale, lots, land, and new construction. So this is for resales where it talks about repairs. The buyer and the seller may negotiate repairs on an amendment during the buyer's right to terminate period, and that is form RE 262. Now, in the standard terms under this paragraph, the only thing it says about repairs is they must be done in a good and workmanlike manner. They must be completed 3 days prior to closing, and again, that would be 3 calendar days. And the property must be in the same condition as it was at closing as it was on the acceptance date, normal wear and tear accepted, must be broom clean, and all garbage, debris, and personal property must be removed. Now, where this says damage prior to closing, this talks about if the property is destroyed or materially damaged between the acceptance date and the closing date. And this would be due to something like a weather condition or fire or hurricane or flooding or major vandalism. And basically, in essence, the seller can restore the property to the condition prior to closing. The buyer may terminate, or the buyer or seller can terminate, or the buyer can go ahead and close on the property with the damage if the seller basically transfers all insurance proceeds to the new buyer. So that's what all of that information is talking about. Under the brokerage paragraph, paragraph 8, it says all parties represented by a broker, so that's the buyer and the seller, and this is where all of this is all spelled out. Again, this is a protection for you as an affiliated licensee as well as for your brokers. It says the broker only owes a duty per the listing or buyer brokerage agreement. So if their public people have signed a client relationship by virtue of the brokerage engagements, the duty owed is completely spelled out in those documents, as well as in BRETA, which is the Brokerage Relationship in Real Estate Transactions Act, which is law in our state, official code Georgia annotated 106A1. You can always look that up to, we need to teach a class probably on BRETA. We haven't taught one in several years, and that probably would be a good class. Then, now look at this. This says that the buyer and the seller affirm that they are not a current party to another brokerage. So a buyer or seller, they say they have not signed, this says they agree that they are not working with another broker. And if they are, they may owe money to that other broker. So this is where it says Seller and buyer agreed that they represent their own interests, not dealt with another real estate broker or agent other than the one here in this contract, so as to create any legal right or claim in any broker for commission. Because if a buyer or a seller has signed a client document with another broker and it has not been mutually terminated between them and that other broker, if they work with you and forget to tell you or misrepresent that or just don't understand that, and you close on a property, that public buyer or seller might owe their former broker commission as well. So this is putting the burden on the buyer, saying, look, buyer or seller, you need to, this is saying that you don't owe any money potentially to another broker. Now, this section down here says that the buyer or seller who have not signed a listing agreement or a buyer brokerage agreement, they are working as a customer and they are responsible for protecting their own interests. Okay, here, I knew I had it somewhere. So we've already talked about this at the beginning of class, which is what creates the client relationship. And the forms are for a seller, it's RE 151, which is the exclusive right to sell, RE 150, which is the buyer brokerage agreement, and the customer relationships is for the seller is RE 158, seller authorization to show property without a listing, and RE 159 is the acknowledgement of a customer. Now, I will note on here, I don't have it on here, but the non-exclusive right to sell and the non-exclusive buyer brokerage, those also create a client relationship with the public and your broker. It's just that those documents, the non-exclusive, create a client relationship between the public person and any broker, and the one that gets paid is the one that's responsible for being procuring cause of sale. The customer relationships are here, and even the customer relationships, well, all of them describe compensation. All right, there's another section in the standard terms under the second paragraph 8 where it talks about disclaimer and liability. Hang on. And again, these are paragraphs that your brokers absolutely love. And basically what it says is that the parties have not relied on any advice or representations, and that the broker, and by virtue of the broker, it means you as the affiliated licensee also, have no liability for any perceived advice. If there is liability, then the amount of liability is limited to the amount of commission. All right, I'm getting a question about an encroachment about a gate into the driveway. That would be a matter of buyers should have a survey done. All right, dual agency and designated agency. I knew I had these slides there, but anyway, this is what we have already addressed pretty much in depth at the beginning of the contract. It's just described here. And then default. This changed in 2019, in May of 2019. This default paragraph changed. And basically what it says is if a party defaults on the contract or breaches the contract, if a buyer defaults, the only remedy for the seller is earnest money. That is the sole and exclusive remedy. They cannot sue the buyer for damages. They can't sue the buyer because they're going to lose out on another house. They can't sue the buyer for the cost for a moving truck they've already hired. Now, again, as I said earlier, a party can always sue somebody, but chances are they're not going to win that lawsuit because they've signed the purchase and sale agreement where they acknowledge that their sole remedy is earnest money. There's no grounds to sue for damages within this contract that they have signed. If a seller defaults, then the buyer either gets back their earnest money or the buyer can sue the seller for what's called specific performance. Again, the buyer cannot sue. There's no grounds for the buyer to sue the seller for damages. For example, moving expenses, cost of appraisal, cost of inspection. Again, anybody can sue anybody, but are they going to win that lawsuit? Well, you look at the document they signed and see what the grounds are. But they can sue for specific performance. And what specific performance means, it's legally, it's an equitable remedy in the law of a contract whereby a court issues an order requiring a party to perform a specific act, such as to complete the performance on the contract. So in essence, if a buyer sues a seller for specific performance and wins, that means that the seller must go through with this contract and sell the house to the buyer. No, it's not a free thing. The buyer still has to pay for it. And that's if the buyer is ready, willing, and able to pay for the property. So bottom line, in practicality, if one or the other party defaults, the remedy is that the non-defaulting party gets their earnest money. Now, what happens if one of the parties defaults? What is the broker's remedy? Well, the broker can seek to pursue the commission that would have been earned had this transaction closed. And you also have to look at the terms of commission and default on the brokerage agreements, the buyer brokerage agreement and the listing agreement. All right, notices. The notice section is that anytime the contract says something about notice, buyer must send notice to the seller, escrow agent must send notice. It must be in writing. Text is not a legally recognized form of written communication with respect to contracts for real property in the state of Georgia. Notice may also be sent by hand, courier, fax, email, or registered or certified mail. If it is sent by email, it is deemed to be received when the sender can prove they sent it. And it must be sent to the address on the signature page. So if you're sending it by courier or US mail, it must be sent to the physical address that's on that signature page. If you're sending it by email, notice must be sent to the email that's on that signature page or fax number. If your email address, physical address, or fax number changes from what has printed or pre-printed on your signature page, you have to do so with notice within 5 banking days. If the public has an agency relationship with a broker, then the broker may accept notice for that client. In other words, it can be sent to the agent or the broker rather than to the actual public client. And you will see right here, this very last sentence, notice by telephone shall not be effective. That's another reason why text is not recognized, because text is sent through a telephone. Now, there's a whole bunch of information here, miscellaneous paragraphs regarding the contract. One of the things I absolutely want to bring to your attention is this survival paragraph, paragraph 12.7. This, in the RE Forms contract, it says, unless expressly agreed otherwise in the contract or any other document, the provisions of the contract shall survive closing. Survival means that a party's obligations per the contract continue even after the closing date had they not been completed prior to closing. I will point out that this is a huge difference between the RE Forms contract and the GAR contract. In the GAR contract, there are only 5 specific things that survive closing. Commission, warranties of the seller, condemnation rights, title, and anything that the parties agree survive closing, but nothing else survives closing. In the RE Forms, everything survives closing. And further on in the definitions, it talks about acceptance or binding. We've talked about what that is, but it must be in writing, and it means no changes to the offer or counter offer, and it's notice of acceptance. And it also defines broker. The broker, anytime it uses the word broker, it means the qualifying broker or the affiliated licensees. It also goes on to define buyer, seller, party, broker. Again, it talks about a customer or a client. And when it talks about buyer or seller, it references all the parties named in the contract. All right. Whew, that's a lot. Let's go on for frequently used disclosures. That in essence is the core of this course, but I want to address some frequently used disclosure forms and a couple of amendments. So these are the most frequently used disclosure forms: the lead-based paint and the EPA pamphlet on Protect Your Home from Lead-Based Paint, seller's property condition disclosure, bill of sale, community association. So the lead-based paint is RE 140 and 141. The EPA, you have to use it if the house was built prior to 78. And per the EPA, you must get the buyer's signature and initial on these documents on the disclosure prior to going binding. And the EPA pamphlet must get to the buyer prior to going binding. That's an EPA regulation. All right. So what about radon? I'm not sure what your question is about radon. Under the seller's property disclosure form, it does say that this disclosure form is not a substitute for the buyer's inspection. Again, you guys, how many times in these documents have we put the buyer on notice? Check it out, get it inspected, do a survey, check out the zoning, check out the online documents, so forth and so on. It is that this disclosure form is not a warranty of any kind by the seller, not a substitute for any inspections, and it is the buyer's responsibility to obtain independent professional inspections, surveys, environmental tests, public records, and any other information available. And then there's a lot, excuse me, there's a lot more on the seller's disclosure form, but one of the important things I want to point out to you guys is there is a section where it talks about, look, oven, range, refrigerator, dishwasher, microwave, so forth and so on. All it asks is, are there any known material defects? Nothing about the seller removing these items from the property. If you are familiar with the GAR property disclosure form, there is a whole page where it looks like very similar items, and it talks about if a seller is taking those items with them. This just says, are there any known defects? So you listing agents, if you go binding under the RE Forms Contracts, and a seller is going to remove an item like a refrigerator, chandelier, so forth and so on, you need to use this special stipulation that is available in that library about removing fixtures prior to closing. And it says it's understood and agreed no later than X number of days prior to closing. Seller shall remove the following fixtures from the property and repair any and all damage resulting from the removal. Items to be removed are, that would be, for example, sub-zero refrigerator in the kitchen, or chandelier in the dining room, or something like that. Should the seller damage and not repair the property during removal, buyers shall have the right to either terminate the contract with notice no later than midnight X number of days, and the earnest money gets refunded to the buyer, or waive the right to object damage, so forth and so on. But again, this is not a given in the property disclosure form. No, the EPA does not require the radon pamphlet to be shared by law, just the lead-based paint. All right. Oh, the dreaded community association disclosure. The community associations have become a huge issue in Metro Atlanta. The fees, not the HOAs themselves, but the fees. And it's really not even the HOAs. It's not your neighbors that are sitting on the HOA board. It really comes down to the management companies that your HOAs have hired to manage all the financing. So there ends up being a lot of money involved and a lot of fees to get the proper documentation from the HOA and the management company in order to go to closing. In essence, a seller has to get basically a clearance letter from the HOA saying that they are good and paid in full with the HOA and they don't owe anything. And then buyer has all kinds of fees. There's a lot of times a transfer fee, an initiation fee, excuse me, and all of those kinds of fees. The problem that we are experiencing in practicality is a lot of the HOAs and the management companies will only speak with the seller. who is a current member of the HOA. They won't talk to a buyer. They won't talk to a listing agent. They won't talk to a buyer's agent. So the community association disclosure is worded in such a way that it is not meant financially to punish a seller. It is just meant to have some consequences to a seller for not helping, because a lot of times a seller is the only one that can get this information. So the first thing is, it does say this exhibit shall control. And bottom line, the seller must disclose the accurate fees, or regarding even the buyer's cost, or if the seller doesn't do it, the seller is required to pay for those at closing. But it does say that the buyer is responsible for checking out the HOA and the covenants and restrictions. So here's a section where it talks about the buyer's responsibility. And the buyer is responsible for obtaining and reviewing the covenants, conditions, and restrictions of the community. The buyer is responsible for getting adequate insurance and also checking out rental restrictions. We've had a lot of investors that have purchased in townhome communities only to find out that they bought it as an investment property to rent out, only to find out there are rental restrictions. That is a buyer's responsibility to find out. And it does say the seller does not warrant the accuracy of the information. It is, again, on a buyer responsibility. The seller's responsibility, however, is to disclose all the fees that are required with respect to the HOA and the management company. And if they learn of any changes in those fees, they have 3 calendar days to update this exhibit and disclose those changes in fees to a buyer. At closing, the seller must pay any fees that were not accurately disclosed or not timely updated. So there are a ton of fees that have to be disclosed and discovered and investigated and disclosed to a buyer on this form. Property association fees, initiation fees, master association fees, special assessments, voluntary association fees, recurring dues, admin fees, and other fees. And in essence, again, if you are a listing agent working with a seller, and your seller is really sort of non-complacent about their HOA. Oh, I never go to meetings. I don't know when they are. I don't read the minutes. I don't know anything about that. If you're working with a seller who's getting ready to sell their property, your sellers need to all of a sudden get interested in the minutes and what is going on with their HOAs, and probably get a copy of the covenants, conditions, and restrictions. The CCRs are available online. That is recorded with title. So hopefully a seller has those and can readily provide those to a buyer, but a buyer can find those online, and you might need to get the help of a closing attorney to find those. I believe they may either be in the Georgia Secretary of State or in gsccca.org. Fireplaces inspected up to a buyer. Nothing has to be inspected, y'all. It's all completely up to a buyer. Buyer doesn't even have to have any inspections done. It's just saying that they are on duty. If they want inspections done, it's up to them. It's not up to an agent or anybody to tell them about the property. Notations about property items remaining. No, I would not put a notation in the seller's disclosure form about like a refrigerator or something staying with the property. I would handle that either as a special stipulation. Actually, I would handle that as a special stip. All right, moving on with the contingencies. I'm sorry, that was it for the disclosures. Now we're going to talk about the frequently used contingencies: backup, sale or lease, and just generic. The backup contingency form is RE 252. And in essence, what all of this says, I'm just going to summarize, is there's only one backup offer, because the backup offer has to reference a primary contract. So if you're a buyer's agent and you're talking to a listing agent who has a property under contract, and they say, yeah, we're under contract and we've got 3 backups, that's just not true. You can have 3 interested offers or 3 other interested parties, but you can only have 1 actual backup contract, because you do have to cite the primary contract. Earnest money is due just like any contract when a buyer and a seller sign the contract, but all contingency timeframes All the other rest of the timeframes in the contract begin once the seller sends notice that this buyer, this backup buyer, is now the primary buyer. Before getting that notice, the buyer may terminate at any time and get their earnest money returned. That's the core of the backup exhibit. Excuse my misspelling there, but the sale or lease contingency is RE 251. And basically, this means that a buyer currently lives in a house, they want to buy the new home, but they're making their purchase of the new home contingent upon them selling their existing home. So you have to put, if it's a sale or a lease, and you have to put the address of the current property, and you have to put in a time frame that this contingency shall expire, just like all the other contingencies, X number of days after the contract acceptance date, and that's known as the contingency time frame. Now there is what we call a kick-out clause in the sale or lease contingency exhibit, and basically the buyer and the seller negotiate that there is a kick-out or there is not a kick-out. So you have to put it shall be. They call it demand to remove contingencies. It is part of this contract or it is not. If the buyer and the seller negotiate that there is this kick-out or demand to remove contingencies, basically what that means is the seller may continue to market the property to another buyer. They can continue to market the property actively for sale. Now, in the contract, that says they can market the property actively for sale. However, in your MLS services, you can't list it as active, but they have other labels where you list the property, either active with conditions or active with kick-out. There are other categories in your MLS system how you would market this property. Then if the seller gets another buyer, so the seller's under contract with this buyer, they find another buyer that they want to sell the property to. First of all, listing agents, do not kick out your primary buyer if you have not thoroughly negotiated your offer. Listing agents, this is for listing agents only. If you are under contract with buyer number one and they have a sale or lease contingency and you do have a kick out, you get buyer number two that you want to sell to. You are going to thoroughly negotiate that purchase and sale agreement and then include this backup contingency exhibit. Once you get a binding contract with buyer number two as backup, then you are going to send notice to this current buyer of the kick out. Don't kick out your buyer before doing that, because if this buyer terminates and you never negotiate with buyer number two, you're back at square one. So basically, if there is going to be a kick out, you negotiate that the buyer has X number of hours to send notice that they're either going forward with this deal or they have to terminate. If the buyer says, yep, I'm going to go ahead and go through with this deal, I want this house, at that point, all buyer contingencies are removed from the contract. So buyer number one, they get notice from the seller that they're being kicked out. They have X number of hours, and we see anywhere from 24 to 72 hours. If they are going to stay in the contract, that means they have to close. There's no more protection for their earnest money under buyer's right to terminate. There's no more appraisal contingency protection. There's no more finance contingency protection. There's no more protection if they don't sell their current home. If they don't close for any reason, they will be in default of this contract and will lose their earnest money. If a buyer is not in a position to do that, then the buyer must terminate this contract. Now, there's also a thing, what if a buyer just wants to remove the sale or lease contingency? We have a lot of buyers that, look, I can qualify to have 2 mortgage payments, I just don't want them. So a buyer can always say, look, I want to stay in contract with you. I really, really, really want this new home. But I still want my appraisal protection. I still want my financing protection. I just want to remove that I don't have to sell. I'm not making this contract contingent on my selling my current home. That can happen. The buyer can voluntarily remove just the sale or lease contingency. If they do that before they get notice of the kickout. So that's an interesting thing. All right, a few more things. Other procedural forms, counteroffer form, and we talked about that at the break. Notice of acceptance date, we've talked about that. Commission acknowledgement, after you go under contract. Actually, if you are a buyer's agent and you write an offer, I strongly suggest that you fill out this commission acknowledgement, and you don't make it part of the contract, but you're going to send that to the listing broker the same time that your buyer is submitting their offer. You want to make sure that your broker is getting paid so that your broker can pay you. So a lot of times agents wait on sending this commission acknowledgement until after they're binding, but there's no reason, and I strongly urge you buyers agents to send this. Again, it's not part of the contract, but you would fill this out and send that to the listing agent, and you fill out the offer and the standard terms, and you send that separately so that the listing agent can then send the offer and the standard terms to the seller, but the agents themselves negotiate through or sign this commission acknowledgement. And then the unilateral notice to withdraw, or the notice to withdraw and terminate, and notification. Also, a couple of amendments. There is amendment during the buyer's right to terminate, and just a general purpose amendment. All right, let me see how much more we have to go. Okay. All right. So the amendment during the buyer's right to terminate. So remember, the buyer made the contract subject to their right to terminate period, and let's say we put 10 days on there. During that time frame, a buyer does all kinds of things to help them make the decision if they're going to go through with the sale or if they're going to terminate. So one of the things that they do could be to hire an independent home inspector and check out the house. Through the course of that inspection or whatever, they could find some things that say, hey, Mr. and Mrs. Seller, I found some items that I would love for you to figure out, I would love for you to repair those items because I don't want to spend the money to repair them. So on this amendment during the buyer's right to terminate period, this is where a buyer and a seller negotiate, submit an offer, and then negotiate for the, let me see where I have it. This is where you fill that out, you reference the property, and then here's where you fill out that says the seller agrees to amend the contract. In other words, the seller agrees to do this. And this would be, seller to replace rotten wood around windows and repaint to match. Seller to reverse polarity in the GFIC outlets, blah, 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 blah. At the bottom of this document, it says this amendment shall or shall not act as a unilateral notice of termination of the above reference contract if it is not accepted by the seller and delivered back to the buyer prior to the end of the buyer's right to terminate period. What on earth does that mean? Well, in essence, what that means is, let me go back to the PowerPoint. What that means is if it is what I call a make it or break it repair item. For example, if the property needs a new roof, or for example, if there is a structural foundation. This is something that the buyer is absolutely not going to go through with this contract if the seller does not fix it. If it is a make it or break it item, you buyers agents, you would probably want to put, yes, this shall act as unilateral notice. In other words, if the seller does not sign agreeing to replace the roof, for example, and get it back to the buyer before the end of the buyer's right to terminate period, then the buyer, this acts as a termination notice to protect the buyer and they can get their earnest money back. If that is not done and this amendment is not signed by the buyer and the seller agreeing to repairs, then the buyer is buying the property as is. So that would mean the buyer would have to buy the property and put the new roof on it themselves. So that's why you're going to put shall if it, again, is a make it or break it issue. Again, I'm getting a question about, well, I'll answer that at the end. All right, note about repairs. You guys, remember in the standard terms when we addressed repairs, it just said they must be done in a good and workmanlike manner 3 days prior to closing. That is it. So what happens if a seller doesn't do it? What happens if you have an amendment to address concerns where the seller agrees to replace the rotten wood, reverse the polarity, blah, blah, blah? Or replace the roof even. What happens if a seller doesn't do it? Can the buyer terminate? Not necessarily, you guys. There are no termination rights built in to anything addressing repairs. You guys, you have got to address the consequences for a seller's lack of performance when you are addressing repair issues. So there are a variety of special stipulations regarding repairs. The RE Special Stipulations Library, RE Forms Library has a bunch, or I have a bunch for you that you can access. And this is where you access any of the forms. You are going to go online and you are going to go to www.eagentweb.com. No password, no nothing, eagentweb.com. You're going to click on this tile where it says training videos. You are going to scroll down. These are a lot of our CE classes we've offered and the handouts and video recordings. Here's this class I'm teaching right now. Here's a copy of the PowerPoint slides. Here are a copy of all of the RE forms we've been going over. They have all those underlined marks on there. Here are the Special Stipulations Library. Here is a document that I'm talking about right now. Repair stipulations to consider. And what those look like, I'm gonna move this over. Do I have it? Oh man. All right, I thought I had it up here. Basically, what those, I guess I'll just download it here. There are, I am providing for you guys, please check with your broker if you are not a maximum one agent. I have 2 pages of special stipulations to discuss with your broker, with your buyer, negotiate with a seller to address this issue. What happens if a seller doesn't do them? For example, all parties agree that the work shall be done prior to closing. If not, here's where you would build in termination rights for the buyer. Or this is an RE form special stip. You can escrow money at closing for them to take care of that. Or here is a GAR special stipulation, repairs paid by the seller after loan approval. Or you can have the seller write a check to a vendor at closing. But the point is that I'm trying to make is that don't address this issue at the closing table or 3 days prior to closing. You've got to address consequences to a seller's lack of performance on this amendment when you are addressing repairs. And it's not that the sellers are necessarily bad people and not do them, but throughout the course of events, there are a lot of things that happen where those repair issues may not get done. They may not be able to find the contractors to get them done, or they may have negotiated on a sale price and just changed their mind. There's a lot of issues. Okay, whew, I'm getting out of breath. All right. Terminating a contract, forms required. Now, terminating a contract and releasing the earnest money are 2 separate contractual issues. In our industry, among your co-op agents and even among your brokers, you will hear the euphemism a T and R, and that stands for T and R. And because these contractual issues go hand in hand, but they are 2 separate issues. Terminating a contract is one thing, and agreeing to release the earnest money is another thing. So in the RE Forms contract package, these 2 separate issues are handled on 2 separate forms. The RE 263 is the notice to withdraw or terminate a contract. Notice means it's unilateral, means it only needs one party's signature. So termination is unilateral. Either a buyer or a seller may terminate. Now, do they terminate based on an agreed upon contingency, or do they terminate by default? That's a whole separate issue and has to do with the earnest money, but once it's terminated, it's terminated. So you would use the form RE 263, notice to withdraw or terminate, to actually terminate a contract. Then you need a separate form, RE 212, to agree to disperse the earnest money. Again, terminating or withdrawing is unilateral. So again, all right, I went over that. If both parties don't agree on the disbursement of the earnest money, it's in dispute, and we do one of those issues, either that 10-day letter that we talked about, or the escrow agent can interplead it into a court and let a judge decide. If the contract is terminated by an unexpired contingency, but the other party just won't sign, again, the earnest money is in dispute, and more than likely the escrow agent is going to do the 10-day letter. One other thing, if the earnest money is addressed in the creation of a contract, then it must also be addressed in the termination of a contract. So you must fill out that RE 212 even if the earnest money has not yet been remitted. So this is the notice to terminate, RE 263. And if you're already binding and it's a termination, you're going to mark this box, insert an accepted contract. You put in the acceptance date is hereby terminated, and you put in the reason. If you are withdrawing an offer or a counter offer, you're going to use the same form, but you're going to mark this box that you're just withdrawing your offer or counter offer. So to release the earnest money, not only the contract, but license law says that the holder must have written agreement and signatures between the buyer and the seller directing them on how to disperse the trust fund. So you're going to use RE 212 to address that earnest money when a contract has been terminated. This is bilateral. Agreement means you need both parties' signatures. So this is the form RE 212, and you're going to put the trust funds being held by, and you put in the name of the holder or the escrow agent, shall be dispersed. And I really like this form because you can fill out either all of the earnest money payable to buyer, and you're going to put the buyer's name and their address, or seller's name and their address. Or this has a really nice place where the buyer and the seller can choose to negotiate to split up the earnest money, and you just direct the escrow agent how to disperse those funds. Before the escrow agent does disperse any trust funds, earnest money, or security deposit, for example, that they're holding, they have to have cleared the bank, and we can give the money back to a buyer if they never go under contract. It either gets credited to a buyer at closing, or it gets back to a buyer if the earnest money is not credited at closing. For example, let's say a broker is holding earnest money, and for whatever reason, on the closing statement, the closing attorney did not give credit to the buyer for the earnest money that was already on hold with one of the brokers. So the closing statement itemizes all the money. The buyer brought additional money to closing. So now the holder is holding an overage of the buyer's funds. We can then cut a check back to the buyer for that overage. Or pursuant to a separate written agreement signed by the parties, and that's that form we're talking about now, RE 212. And again, we've already talked about this. If we get a court order, we talked about the 10-day letter. We talked about all that. I just have a double slide. All right. There are also a lot of consumer, let me go back to this slide just for a second. Again, there could be a time when a buyer terminates within the time frame. Let's say they terminate within, and the reason is buyer's right to terminate period. They had agreed to a 12-day period and they terminate on day 5. Even if a buyer does that, if the seller won't sign the RE 212, the holder still has to go through that 10-day letter. All right, moving along. Consumer brochures. The RE Forms does have a variety of consumer brochures. We've talked about the lead-based paint and the EPA pamphlet. There is an EPA guide to mold and moisture. These are the only two right now that I am aware of that the EPA can levy a fine on the broker, on the agent, on the buyer, well, not the buyer, but on the seller for not making these proper disclosures within the amount of time and getting initials on these documents. There are other EPA guides, but I'm not aware of any fines that the EPA can levy based on that. Here, there was a question about radon earlier. There is a consumer brochure, RE 144, Citizen's Guide to Radon. There is a general brochure, Home Selling the Process and Home Buying the Process. And I strongly, strongly urge you guys to get any consumer brochure into the hands of your buyer and your seller when appropriate. Just the more information they have, the better. Now, do they read them? Who knows? Do they read the purchase and sale agreement? Who knows? Do they read the standard terms? Who knows? But you, as an independent contractor working with that public person, can absolutely be better protected if for any reason you have to have an issue with your broker, a co-op broker, an arbitration board, a judge. You will definitely have a better defense, so to speak, if you can demonstrate that you, as the real estate agent, did everything within your power, whether you are working with your public people as a customer or as a client, that you did everything within your power to get this information to your public people so that they can make an informed consented decision. So you want to be able to demonstrate by virtue of email with attachments, by virtue of electronic signatures or initials, that you get everything to your party. You also, if you have a phone conversation with your client or customer or co-op agent, the best thing to do, this is a point of practice, is especially if you're just discussing something materially relevant to the contract, you are, after you hang up the phone, you are then going to go write an email that just says, just to summarize, the nature of our conversation was blah, 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 blah. If you understood our conversation to be anything different, please let me know. That way, it's not really written, but you have written documentation of a phone conversation. And again, I think the best thing to do, we don't want contracts terminating. We don't want commission for a deal that doesn't close. We want happy buyers and sellers. We want commissions without having to go through any process, legal process, to get them. So the bottom line is, let's do everything we can to keep these deals together, to make sure that our buyers and sellers, our clients and customers, our co-ops, our brokers, our closing attorneys, and our lenders have all the information they need to make informed consented decisions and go about achieving their end of getting the home, buying the new home that they want and selling a home that they no longer want, conveying good and marketable, unencumbered title. Whew, we made it. So again, I'm going to stay on for a little while to answer any questions. If you did not do so at the break, please type in your name, email address, and real estate license number. If you did at the break, you're good to go. I thank you guys so much. I hope that you really enjoyed this class and that you got way more information on the RE Forms contracts. And they're not quite so scary if you're not familiar with them. If you are familiar with them, that you understand them a lot better. Please, please confirm any and all contract questions with your own broker. We are working on the July classes as we speak. So they will be published at registerforreclasses.com, and you're going to select a geographic area. I will give you a hint. If you go to this website right here and select Marietta, that is going to have all of the virtual classes on there. But a lot of these calendars are overlapping, so you will find a variety of classes there, and feel free to select a variety of geographic areas right now. In July, we are going to have some virtual classes, and we are going back to having some CE classes in actual offices. The courses are through the Georgia Real Estate Academy, GREC School 6915. We do take 3 to 5 business days to post these credits. We're not going to contact you when they're posted. Check your own GREC record. And again, the YouTube channel that I do is called Real Estate Made Crystal Clear. years and years worth of contract tips on both the GAR contract forms and the RE forms, as well as license law and some other issues. I thank you guys so much for your time. I am going to stay on for questions. If you're not asking a question and just want to hear an answer, please keep yourself muted, and have a joyous and prosperous and healthy rest of the year, helping others with their real estate needs. I'm going to stop the share and go back. Thank you guys so much. And I'll stay on to answer any questions from anybody. Thank you. Thank you guys for your time. I appreciate everything. I've got the chat open, or you can first Zoom class. Oh, thank you. Thank you, Brenda. Yeah, the Zoom classes are interesting. They're a little bit different with interaction wise, but I appreciate that. It's nice being able to sit at home and take it. Thank you. Thank you, guys. I appreciate your time.
Okay, most Zoom class I attend, when they send you an email with the meeting ID, they also send you a password. But I didn't get no password, so I have to log into my email.
Yeah.
Just want to let you know.
Thank you. I appreciate that. We have a registration with your license number, but we didn't have a password on this.
Okay.
Awesome. Yep. The RE form is not quite so scary. Again, I hope this class really helped you understand them a little better. Again, for handouts of all of those exhibits with all those underlines, as well as the special stipulations, if you go to, I'm typing it in the chat, eagentweb.com, click on training videos, and then find this class. There's a lot of information about other classes we teach there. You obviously won't get CE credit, but you can see other information that you might find useful as well. All right, just type that in. Thank you. Thank you, guys. Appreciate everything. Appreciate your time. Awesome. Yeah, I haven't taught this class in a while.
Dana,
Yes.
I was wanting to know if you offer a trust account class.
No, we do not have a trust account class through the Georgia Real Estate Academy, but there is a fabulous trust account class through GREC. If you go to GREC's website, and they've redone it recently, so it's a little bit difficult to find, but GREC in and of itself will have a link to a trust account class. That is a fabulous class. It's very scary, actually, but it is a great class. So you can find that through the Georgia Real Estate Commission.
Okay. Thank you.
You're welcome.
I enjoyed the class.
Thank you. Appreciate your time. All right. Any other? Nobody's leaving. I know some of y'all just want to hear answers to questions, other questions that are being asked. I see a couple people on by phone. For those of y'all that were on by phone, in the chat section, please make sure that you put not only your name, email address, and license number, but your phone number as well. Thank you. I love teaching you guys. It's one of my favorite things of my job that I do. I really enjoy teaching and informing, and I love teaching, especially contracts classes, in a way that makes sense to you guys as the agents when you're out in the field, so that you don't have to think about, ooh, what did I memorize or learn in the class? But I try to teach it in such a way that it makes sense to you to either look through something or try to remember something. I also teach a GAR contracts class, and like I said, that compare and contrast class between GAR and the RE forms. There is another class later on in the year I will be teaching called Weird Contract Forms, and that is a thorough look at all of the other forms that we don't have time to address in a contracts class. The buyer brokerage agreement, the listing agreement, the commission instructions, some of the other amendments, some of the other exhibits other than the financing issue. Some of the ones that are used on a regular basis, I usually address in the contracts classes, but some of the other ones, the temporary occupancy agreements, that I go over those in depth in another class, again, called Weird Contract Forms, that I don't have scheduled anytime. I know it's not scheduled in July, but maybe in August or September. So take a look at that. Are these classes talking about virtual? So starting in July, some of our classes that we're offering through the school are virtual. Some of them are in branch. And right now what we're talking about doing, I'm teaching them all in branch. But what we are talking about doing, because we're able to be able to touch so many of you guys virtually rather than in the branches due to geographic constrictions or restrictions or, you know, convenience. What we're looking at doing right now is actually teaching. I'm going to teach in branch, and I'm going to see if I can actually Zoom in branch. So instead of seeing the logo and the white background behind me, you will actually see me in a live setting, but it will be Zoom. So that's what we're looking at doing in July. Again, we're finalizing all of these issues this week. Switch to phone. Okay. Thank you, Sheila. Got that. Yep, that would be great. I think so too. I think that's what we're going to do for July. And then again, we are sort of taking this on a month-by-month basis based on what is going on in the world and in Georgia specifically. All right, everybody. I don't see any more pressing questions. You guys have a wonderful day. Now is a great time to be in touch with the public. Let them know what's going on. Again, the market really is, we have a lot more buyers than sellers because interest rates are low and are staying low. The sellers do have equity in their home, so we've got a lot of sellers where it makes sense for them to go ahead and sell, and they're getting money out of their homes, and just a lot of other issues. Michael, I see you have a question. If you want to either speak or type it in, that would be great. You might be typing as we speak, so I'll wait just for a couple minutes. All right. Chat. All right, here we go. 12-month rule for taking CE. Does it reset after renewal or going to be 12 months? Oh, that's a really good question. Okay. I believe GREC has been a little wonky lately with their website. So the question is, if you renew, so your license is due every 4 years by the last day of the month of your birthday month. You can renew with GREC early. It's up to like 3 or 4 months early. They will take your money at any time. If you do not have all of your CE credits, especially if you do not have your license law credit, they will take your money, but they will go ahead and inactivate your license until all of your CE is done. So number one suggestion is don't pay your renewal with GREC until all of your CE is complete, 33 hours of CE plus an additional 3 hours of license law. GREC also has another rule where you can only get credit for a CE course number once every 12 months. So the question is that 12 months for a specific, for getting credit for a specific CE course number on a calendar time frame, or does that coincide with when you renewed your license if you renewed early? So for example, I just renewed my license yesterday, but it doesn't expire until August 31st. So I now have till August 31st of 2024 to have to renew again, but all of my CE credits went back to 0. I'm going to also give myself credit for this class because an instructor can also get CE credit for a class they teach. Even though my license does not expire to August 31st, 2020, since I renewed yesterday, this course will count, I believe, towards my next 2024, towards the hours required for my 2024 renewal. However, for the requirement for getting credit for a specific course number, that is on a calendar. So even though I'm taking this because I renewed early, I still cannot get credit for this 2020 RE Forms Contracts class again until June 24th, 2021. So that was my long-winded explanation, Michael, to your question. So the credit for a specific course number is on a calendar basis, because as the school, when we log the credits into GREC, it does it on a calendar basis, but your renewal and the classes that apply towards your next renewal can go early, if that made sense. So again, long-winded explanation. I hope I answered your question. Anything else, anybody? All right, I am going to finalize the poll. And polling. Share results. Stop share. All right. All right, everybody. I am going to go ahead and stop the class. Thank you guys so much. I appreciate your time, and look forward to seeing you on another class. And go out there and be a blessing with your license and your knowledge and your skills to help the public that is looking for you. Thank you guys so much. Bye-bye.